My lord, if I may have the liberty to mention a matter for urgency, my lord. Essentially, this is running in the monthly list item number 30.
Yes.
It is running in the monthly list item number 327, my lord. But my lord, your lordship had previously passed a judgment on absolutely similar facts, only in respect of another governmental organization, my
But
lord.
that cannot be an urgent matter.
And my lord,
Since I have
pensioners, the elderly pensioners, my lord, a lot of
wait
them,
for some
lot of
time.
the pensioners have
Let
died.
me mention after some time. Let me see.
A lot of the pensioners have died in the meantime, my lord.
Wait for
It's
some.
been pending for a very long time, my lord.
No.
My
Let
lord,
to wait for some time.
may I be permitted to mention, my lord, this is an extreme urgent matter. I lord, this matter was earlier mentioned to my lord Justice Aniruddha Roy, and it was fixed on 4th of November, but due to change of determination, this matter
What is the urgency?
urgency is the 12th November is the date for DME. The similarly candidates who are CRPF candidates who had 169.5 will be considered at 170. My lord had earlier passed, Justice Aniruddha Roy also passed the similar order. I am also on the same
When the
footing.
date is fixed for DME?
From 12th December, my lord.
12 December.
12 November, sorry. 12 November onwards, it will start, my lord. Similar matters
How long it will continue?
from the up to December, my lord. But the matter is not the list. What happened, my lord? Initially, the matter was in the list. Then matter was supposed to fix on 4th November. But due to change of determination, my lord, matter is not in the list. Kindly take it up on Tuesday or Monday, whenever my lord's convenience. Similar order is already passed by other coordinate bench also.
Mention on Monday. Yes, call the list.
স্যার আমি ইন পার্সন আমার কেসটা করছি আমার মেনশন
Who is she?
আমি শুক্লা সরকার স্যার
Just behind you.
Huh?
Who is she?
Yes, sir. No. Permitted mention in one matter.
Another matter. Not her matter. Yes, come forward, mention.
স্যার আমার লয়ারের জায়গায় আমি স্যার এখন ইন পার্সন
আপনার লয়ার কি?
অচিন কুমার মজুমদার ছিলেন।
আপনি কি তার কাছ থেকে নো অবজেকশন নিয়ে নিয়েছেন?
স্যার সব নিয়েছি।
কবে নিয়েছেন?
স্যার অনেক আগে।
আচ্ছা,
পুরো প্রসেসিং যা হওয়ার, মানে 30 নাম্বার কোর্ট, তারপরে 33 নাম্বার কোর্ট, তারপরে এখানে স্যার। তো স্যার আমি মেনশনিং করতে চাই, তো আমি করবো স্যার।
হ্যাঁ, কি আপনার কি চাইছেন আপনি বলুন।
ও স্যার, মানে স্যার আমার কেসটাকে এখানে ইয়ে করা হোক, মানে ফার্দার প্রসেসিং এর জন্য নেওয়া।
আপনার মামলা কি লিস্টে কম্বাইন্ড লিস্টে আছে?
স্যার আমাকে ম্যান্ডামাস থেকে বললো এখানে এসে এখানে এসে মেনশন।
আপনার মামলা কি লিস্টে অ্যাপিয়ার করছে? আছে লিস্টে?
পুরো প্রসেসে স্যার আছে, মানে স্যার এটা
আপনাকে জানতে হবে যে আপনার মামলা লিস্টে আছে কি নেই।
হ্যাঁ স্যার,
আপনি জেনে ভালো করে বুঝে লিস্টে মামলা আছে কি না আছে জেনে সোমবারে মেনশন করুন। সাধারণত খুব আর্জেন্ট মামলা ছাড়া অন্যদিন মেনশনিং নেওয়া হয় না।
স্যার আমি অনেক দূর থেকে এসেছি, আর স্যার আমি 5-6 দিন
আপনি তো বলতেই পারছেন না আপনার মামলা লিস্টে আছে কিনা।
স্যার আমাকে তো অতটা ডিটেইলসে বলেন।
সরি, ইয়েস, কল দ্য লিস্ট। Yes, what for you are mentioning? Is it a day for mentioning? What is the urgency?
Lordship directed that the matter to be placed on motion list today.
Yes.
But it was not.
It was directed.
20th October, Lordship.
So far back, you have to mention again before this court. You have to satisfy this court whether matter is urgent or not, and then you can the matter will be included. Automatically, it will not be included. So, is there any urgency in the matter?
Yes, Lordship. Illegally.
What is the urgency in the matter?
Terminated.
When terminated? Mention on Monday. Call the list.
Item number 1.
Lord, I appear for Union of India and AIIMS. But one thing, Mr. Bhattacharya possibly, I don't know whether he has done it. He has made the administrator party by name. And it is a settled law. If in any proceeding somebody is made a party by name, he has to be given independent notice, whether that has been given or not. The last respondent.
Mohik Ranjan Pal has been served.
Affidavit of service filing, Mr. Bhattacharya.
On the last one.
Yes, please, your case.
My lord, a selection process was initiated, by AIIMS Kollan, at page 22. Vacancy notice on deputation.
Yes,
The post for which I offered my candidature is serial number 10, registrar.
yes,
Now, upon fulfilling the eligibility criteria, at page 36, I was recommended. On selection. And I was serial number 1, nature of candidature, registrar, for the post of registrar.
serial number 1, page 36.
36,
Yes,
against post of registrar. Now, thereafter, page 38, can kindly be looked into. This is my letter of appointment addressed to my previous employer, or rather my employer in Uttarbanga Krishi Vishwavidyalaya. I was recommended for the period from 3 years. Roman 2.
yes,
Then, 29 July 2024, the office orders were issued by my previous, my original employer, Uttarbanga Krishi Vishwavidyalaya, indicating that the leave salary contribution and pension contribution is to be made by AIIMS Kollani.
so you are in Uttarbanga Krishi Vishwavidyalaya.
Yes, as assistant registrar. Now, thereafter at page
Just a
40
minute. Yes.
Now, then for 42, I join, my lord. It is recorded in AIIMS order by the senior administrative officer then that I join on 1st of August 2024.
Page
42. I mean, there were certain issues regarding, my lord, non-release of my benefits, my lord, which were not salary. My lord, it is leave salary and pension contribution from the AIIMS. As a consequence whereof, my lord, page 43 came to be issued at page dated 11th of April 2025, requesting AIIMS to deposit the leave salary contribution plus, you know, other benefits by referring to some government memo of 11th February 2018.
Yes.
Then, my lord, please come to, my lord, an email of at page 46, May 28, 2025, whereby I write to the executive director for remittance of the dues, which till that date remained unpaid, which even till today has remained unpaid. Be that as it may, my lord, this is the communication. And then, my lord, page 51. First is page 49.
Yes.
Then, my lord, page 49, once again, the Uttar Bongo writes to the executive director, giving the detailed calculations about the dues payable to me on account of leave salary as well as pension contribution.
Yes.
I indicate to your lordship, being completely disgruntled over their actions. At page 52,
So
my
this
lord,
leave salary and pension contribution was not being made.
No. Now,
So that was the beginning of the dispute.
if at all, then, my lord, at page 52, my lord, at dated 26 July 2025, my lord, being completely frustrated and disturbed, my lord, I just give a one-line letter. I would like to resign from the post. We are requested to consider the notice period as applicable. As this is a notice for severing the contract, no reason is now referred to. Kindly release accordingly. this
Yes.
was followed by page 53. The approval of the competent authorities conveyed towards premature repatriation of Sri Motilal on deputation after completion of 3 months requisite formal order will be issued in due course.
Just a minute.
On the very next
So,
day,
so this resignation letter was acted upon.
not resignation letter, it says
You
repatriation.
are on lien, and it was appointment was for a period of 3 years. So
Now-
therefore this order,
correct.
this letter was issued on 26 July 2025.
Yes, and thereafter
And
on
it was
8th
responded
August,
to on 8 August 2025.
and on 9th August, I return it immediately saying that this is factually incorrect. There is factual infirmity. I am not accepting this. On 9th August at page 54. Then, my lord, at page 56, I give a detailed representation to the executive director of AIIMS Kollani, ventilating.
Just a minute,
Yes,
page
please.
54. Yes.
And I give a detailed representation, giving them various instances as to why I was not, towing their line, or why I was not being accepted in a congenial manner. Ultimately, at page 59,
Issue is non-remittance of leave salary and pension contribution.
otherwise, why will a gentleman, working in such a coveted post like registrar AIIMS
AIIMS.
would even imagine of,
But that Mr. Bhattacharya could have been sorted out.
yes, it was
Can it
at
be,
page
can it be
59,
an
please see.
issue of praying for release? That could have been sorted out.
Yes, it was sought to be, because immediately at page 59, I withdraw the resignation.
But that is much after the
20th September 2025.
problem is this letter dated 8 August 2025.
Yes, then it was sought to be rectified. After 20th September 2025, page 59, I withdraw the resignation.
What is passing through the mind of the
Yes,
court, I
yes,
should
yes.
express it properly. You tendered resignation letter and
On 26 July.
on 26 July. Authority acted upon by issuing
8
letter on
August.
8 August. And your letter is dated 20th September 2025.
In the meantime, there are 2 letters. One is refusal to accept 8.
All are after 8 August.
All of 8th August. Then, 20th September, I withdraw it. After indicating it to them that I have resignation withdrawal with you, I would like to state that till date I have not received, because I am compelled to state that I am in complete state of ignorance regarding acceptance or non-acceptance of aforesaid resignation. As more than 1 month, 25 days have lapsed without any response, therefore the aforesaid letter could be held to be ineffective and so withdrawn. This withdrawal.
But there is a response.
Yes.
There's a response on 8
Response,
August.
I say that response is good, bad, indifferent, not acceptable to me. At page 54. Then, on 4th October, plus see, page 4th of page 61. They modify 8th August. So it's a modified order which says, that the repatriation is on my own request.
What is the wrong in it? Yes, you requested.
Initially, they did not do so. Now they are writing it.
No, but demonstrate, Mr. Bhattacharya, pausing here for a moment. What is the where is the factual wrong so far page 61 is concerned?
61 does not take into consideration 20th September.
Which 20th September letter?
Withdrawal of resignation. withdrawal of resignation.
But
They
if
just
you-
give a complete go
But
by.
on analyzing the chronological facts,
Now, then, there is a further development. At page 74, 73. Now, just give me 2 minutes. 69.
that recanting is delayed.
No, please see page 69.
That recanting, Mr. Bhattacharya, is delayed.
Yes.
That is troubling this court.
20th September is. Now, please see page 69 for a moment. October 24, 2025. With reference to your query, it is informed that your request for resignation withdrawal is presently under process. The decision of the competent authority will be communicated to you shortly. So therefore, my lord, the moment they issue this on 24th October 2025, so my lord, with greatest of respect to your lordship, my lord, whatever was,
Who is writing this letter? Deputy Director of
this is
Education.
establishment AIIMS Kollani. And then, my lord,
Just a minute.
sorry.
Yes.
Now, thereafter, my lord, the impugned order came to be issued at page 75. Now they act on my letter of 20th September regarding withdrawal submitted by Motilal on deputation for withdrawal of resignation has been duly considered. However, the request has not been acceded to by the competent authority. Motilal will be relieved of his duties with effect from this. To enable him to join such and such, accordingly, is requested to submit his no dues.
And moreover, it was not a substantive appointment. It was an
It was an
appointment only
appointment on deputation.
on deputation,
Yes.
on deputation. Appointment. Not, yes, you are absolutely correct that your engagement letter or appointment letter goes to show that it is not an transfer on deputation. It is appointment on deputation, but it was for a period of 3 years. Now, therefore, where is your appointment letter?
No, kindly falls back to page 40. It is early 40s, page 36. My appointment letter is at effective order is at page 48.
Page 40.
Yes, 38. And page 38 is my terms and conditions.
Initially for a period of 3 years or until further order?
So this until further orders presupposes, there has to be, some issues which, may not be congenial to the employer, and which prompts them to not prematurely send me back to my original post. Now,
Now, Mr. Bhattacharya, if it is considered from a different angle, if there was no rift between the petitioner and AIIMS
he wouldn't have
with regard to remittance of
dues and
pension and leave salary remittance, in that event, whether the authority was not free to take decision with regard to your
100% Milord, upon ascribing
simply on the strength of clause 1 Roman capital 2 of your appointment letter.
Yes, upon ascribing appropriate reasons. Milord, even if
For that
reasons
reason,
are not prescribed,
for that reasons are required to be
with respect, Milord, with respect,
is required to be
Milord,
assigned.
please see page 62 for a moment. This is Ministry of Personnel, Public Grievances and Pensions, Government of India.
Sorry. Page
62. Now, please see paragraph 2. I don't read it for
What
you.
is this office memorandum?
Withdrawal of resignation of central government employees after 31/12/2003 covered under National Pension Scheme. Paragraph
Which part of this?
Paragraph 2A was tendered by the government for some compelling reasons. Will not exactly fits in my facts.
Paragraph 2. Appointment
2A.
2A.
It had nothing to do with my integrity or efficiency or conduct.
Therefore, there is nothing in the intervening period which I have done wrong.
Deputation.
A supplementary affidavit, page 5.
But does it akin to the situation when in the instant case petitioner is working based on this appointment letter dated 16 July 2024?
Milord, please see.
Because
Milord,
it's a
please
case,
see,
it's a
Milord,
case of appointment for a period of 3 years.
With
Had it been a
respect,
substantive appointment,
kindly mark certain dates. Whatever is flowing through your lordship's mind, passing through your lordship's mind, Milord, I accept deposition. Correct. 26 July resignation.
had it been an appointment without any condition for 3 years or until
Milord, I could have, Milord, let me try in my humble way, Milord. 26 July resignation. 8th August, sending me back repatriation to my parent post. 8th August.
right.
9th August, I refused to accept, write to them. Then thereafter, Milord, on 20th September, intervening, there are letters. 20th September, I say that I am withdrawing it. Ultimately, on 24th October, they say that my withdrawal of resignation is under active consideration by the authorities. My withdrawal of resignation is under active consideration. So it presupposes, Milord, whatever decision was there on 8th of August or subsequently on 4th of October, modifying 8th of August, Milord.
So you are trying to highlight, Mr. Bhattacharya ji, just a minute.
Supplementary circuit diye supplementary. No, sir. Relieving order. No.
So these two letters, one is dated 8 August 2025 and another is dated email letter dated 24th October 2025.
In the meantime, there is another 4th October.
These two letters are not in sync.
Apart from that, why I invited my lord to page 61, 62, Milord kindly takes the trouble to have filed a supplementary affidavit. Milord, please see page 5 of the supplementary affidavit. They say the issue is the officer is clear from vigilance angle. It is recorded. My ultimate relieving
There is no question of integrity.
No. So I fit in 2A and 2B of page 62.
And the impugned letter is dated is at page?
Milord, 75. And my lord, apart from that, my lord,
Yes.
apart from that, my lord, page 65, 64 it begins. It is also a government decision of 1988. My lord, the resignation becomes effective when it is accepted and the government servant is relieved of
Which
his duty.
paragraph?
Paragraph 3, page 65.
Paragraph 3, page 65.
My lord. And what I am essentially on is
But
today-
in consideration of this 8 August letter,
8
August
August
letter,
would no longer be.
can it not be, whether it will not be construed that this is an acceptance of your
Not provided 24th October was never issued. Please see paragraph 3 once again, 65.
page 65.
Now, please see page 65. I don't read it. Your lordship reads it in your own way. Twelve six.
Yes, Mr. Bhattacharya, that's all.
Now,
Therefore, your contention is this, first this 2 letters, 8 August 2025, vis-a-vis
24th October.
just a minute, vis-a-vis email letter dated 24th October. Now, even if on the strength of this circular dated 11th February 1988, even if it is construed that acceptance vide 8 of August, but subsequently a request is made for withdrawal of resignation, that has to be considered by the authority and
That they have
reasons
said
has
that-
to be shown.
And that apart, I have not even.
That is the part of
Yes,
paragraph
and
3.
I have not even said for a moment, I did not, because your lordship is looking at page 75. It prima facie does not indicate any reason.
Page 75.
Yes. The
That is
impugned order.
impugned.
It does not prima facie indicate any reason as to why, my lord, the reasons given by me,
How much time is required to complete 3 years?
my lord,
Because
1st
you-
August 2024 is my appointment. 25, 26, 27 it's ending. 31st July 27.
Your appointment letter is 16 July 2024.
Yes, but my lord, my acceptance, my lord, 1st August. My lord, that is recorded. My lord, page 42 may kindly be looked into. 42. 42. It records that, my lord, I have joined on deputation basis on 1st August 24. So, my lord, 1st August to 31st July 27.
Page 42.
My lord.
With effect from 1st August. Yes. With effect from 1st August.
Now, this being the position, now, my lord, I do not know whether I should burden your lordship, my lord.
So up to 31st of July 2027.
Now, my lord, I am tempted to, my lord, cite 2-3 judgments, my lord, only on this proposition, my lord, regarding effect of, my lord, if there is no indication, my lord, in my terms of appointment, resignation or a withdrawal or anything of that sort is not contemplated. So, my lord, the fact remains that I have, during the notice period, assuming 8th August exists, assuming 8th August exists, my lord, during the notice period, I have withdrawn the resignation.
Just a minute, Mr. Chakraborty, page 75 is bereft of any reasons.
My lord, on that issue, I shall make a detailed submission. What is the right, what is the cause of action, everything I will say. He was
No,
found-
court is contemplating to pass an interim order at this stage. So therefore, if a final hearing stage issue can be gone into, but today it appears that when the issue was again reconsidered by the authority, even after the letter dated 8 August 2025.
these are
So
not,
therefore, it goes to show that it is without any reasons.
these are not issues. Your lordship is considering also a memorandum regarding the withdrawal of resignation that has got nothing to do with the deputation. That is in respect of a permanent employee when they shall tender resignation. What is the terms and condition? What is the status of a deputation under Article 16(1) of the Constitution? It has rightly fallen from my lord that this is not a permanent post. He simply cited a deputation with a particular period of 3 years or until further orders. We have covered 3 years from the date initially and the date of relieving. Therefore, we have complied with the requirement number 1.
Is it not an appointment on deputation?
No, deputation has to be interpreted under the Department of Personnel and Training rules. One parent cadre of the state government.
Only one thing, Mr. Chakraborty, will come back. There is a judgment of the Supreme Court 2012 7 SCC.
You know, we have not it.
Ashok Kumar
Ashok
Rotila
Rotila.
Patel.
I have
Rotila.
got also judgment that the
Now,
deputation,
which
deputation is no right at all.
Which says, please come to paragraph 13 of this judgment. Give a copy to
15, 13, 14, 15.
15. Give a copy.
দিচ্ছি স্যার আমারটা মার্ক করা আছে স্যার আমি আমারটা দিচ্ছি
কোন সাল?
স্যার 12/6
আমাদের judgment গুলো দেখো বার করো তো। Paragraph?
13 to 15 input.
Just a minute. Yes, paragraph 13 straightway come. Ordinarily, transfers on deputations are made as against equivalent post from one cadre to another. one department to another, one organization to another, and one government to another. In such a case, a deputationist has no legal right to the post.
Yes.
Yes, such deputationist has no right to be absorbed in the post to which he is deputed. In such a case, deputation does not result into recruitment, as no recruitment in its true important significance takes place as the person continues to be a member of the parent service.
Therefore, from the original appointment.
Come to next paragraph. Mr. Chair. However, the aforesaid principle cannot be made applicable in the matter of appointment recruitment on deputation. In such case, for appointment on deputation in the service of state or organization or state within the meaning of Article 12 of the Constitution of India, the provisions of Article 14 and Article 16 are to be followed. No person can be discriminated, nor is it open to the appointing authority to act arbitrarily or to pass any order in violation of Article 14 of the Constitution of India. A person who applies for appointment on deputation has an indefeasible right to be treated fairly and equally, and once such person is selected and offered with a letter of appointment on deputation, the same cannot be cancelled except on the ground of non-suitability and satisfactory work.
Now, may I now make my case? Your Lordship is referring to a judgment. Now,
And it is, that's why I was asking Mr. Bhattacharya whether it is an appointment on deputation or transfer deputation.
I am coming to that.
Yes.
He has taken so much of time, I shall take just 15 minutes. Now, your Lordship is considering a case admittedly of deputation. Now, it is the settled law on the terms of appointment. Kindly come. What is the term of appointment?
Yes, yes.
Matter is going on. I'll come just.
Kindly come, Lord, to page 38.
Yes, Mr. Chakur.
This is terms of appointment, and Roman 2 says 3 years or until further orders. From the date of initial date to the date of relieving him, we have complied with 3 years. But even then, we are entitled to terminate him until further orders, because the terms of condition will prevail. And on this issue, the law is well settled that a judgment which is passed, even if under Article 141, is consistent finding, will not apply if there is a simple sea of difference, simple difference on fact. No question of Article 141's application.
Yes,
that is settled law now.
That is known
Now,
to
yes.
both of us.
Yes. Now kindly come. What is his case? That he shall be governed by DOPT rules. That is the term of condition of appointment. Department of Personnel and Training, Government of India. Now it is the settled question that whenever a person works, DOPT?
Page 38 second line type.
Yes. Second line says DOPT guidelines on this matter.
Period of deputation shall
This
be
is Department of Personnel and Training guidelines. And that apart, this guideline, your Lordship will consider this judgment is absolutely obiter dictum and par incurium in view of Article 16(1) of the Constitution. This particular provision gives right to a person in service of indefeasible right to remain in service either before appointment or after appointment. But it is distinguishable on a case of a deputation. Now, if on deputation, if it appears to your Lordship on fact that he himself tendered resignation and ultimately the resignation was accepted, whether after tendering resignation he has any indefeasible right, this is transferred to the authorities' right.
Then question comes. Yes, 8 August 2025, a letter goes to show that the resignation was considered and accepted.
Yes.
But then what was the necessity to issue this letter at page 69?
69.
Yes, 24th October 2025. your Deputy Director Administration is saying, page 69, Mr. Chakraborty, please come.
Yes.
Resignation is under process.
69 is his representation.
With reference to your query, it is informed that your request for resignation withdrawal is presently under process. The decision of the competent authority will be communicated to you shortly.
Yes, yes.
And the corollary is page, the impugned letter at page 75.
Sir, first
Yes.
August की
So what is
So
the
therefore, what if it is accepted, then what was the necessity on 8th of August, after 8th of August, to issue this letter or that which is dated 24th October 2025?
Lord, your lordship will kindly consider a particular settled jurisprudential fact that once in service on deputation, not in regular service, somebody tenders resignation. Whether the right is transferred to the employer either to accept or to reject. He cannot unilaterally withdraw this, and even if it is withdrawn, we are not bound by the withdrawal because ball is transferred to our court. Some number one. Number two, the case which is made out that in view of a dispute regarding some payment, he has raised certain issues. Now, what is the term of this resignation? Does he disclose that in view of such disputes, he is not going to continue? Kindly come to the order of resignation at page 52.
Yes.
Page 52. With due respect and humble submission, I would like to resign from the post of registrar. In this regard, you are requested to consider the notice period as applicable with effect from 1st August. I have said we have complied with from the date to tell relieving 3 months. And even if we can, until further orders before that. As this is a notice for serving the contract, so no reason is now referred to. Kindly release accordingly. Therefore, kindly release accordingly. He himself prays for releasing him. He himself tendered resignation. Then whether he can be allowed to approbate and reprobate.
Now come to page 20, just a minute, page 75.
Yes, we are
Not 75, just a minute. Page 65. It's the page 64 is the relevant office memorandum.
64.
Yes.
This is not applicable at all. This is in case of a regular employee of the Government of India, not in case of a deputation employee.
In case of Mr. Chakraborty, in case of appointment or recruitment on deputation and regular employee, what is the difference?
Difference is deputation is limited to a particular period. And once a regular employee is appointed after completion of probation period and he is confirmed, he is governed by the genuine service rules or the jurisprudence. He can be removed on 2 occasions. In Tulsiram Patel's case of 1985 Supreme Court Constitutional Judgment, there are 2 provisions. A regular employee can be terminated on disciplinary proceeding, or if there is a special provision for recording reasons, he can be terminated without disciplinary proceeding. That is settled law of the Constitutional Bench.
If it is on deputation.
No. That is, I am for making a principle of law submitting. That Tulsiram Patel's case said, once an employee is confirmed, he may be removed either by a disciplinary proceeding,
Yes,
or by a summary proceeding if there is a provision, a regular employee. But in case of a employee on deputation, he has no right because he has a right limited to a maximum period of 3 years or until further orders.
so if he has a right up maximum period of 3 years, curtailment of such right does not
Or until further orders.
require reasons while considering his withdrawal of resignation letter.
Kindly consider and visualize this.
Because I am asking you that what was the necessity?
Article 14 will not apply because he himself has tendered resignation.
What is the what was the necessity of issuing this letter at page 69 in that event?
69.
Matter could have been concluded based on the letter dated 8th of August. Page 69.
Yes, that is his letter.
No,
He has-
it is not his letter. Please come to page 69 at the bottom.
Bottom.
Yes.
Refers to your query, it is informed that your request for resignation withdrawal is presently under process. Yes.
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 So after 8th of August, authority is writing a letter on 24th October 2025.
Yes.
That means August, September, October, after 2 months, that your resignations your letter is under consideration.
Not kindly consider that once a
And then a final order was passed that because court has to analyze the facts and then come to a conclusion. Come to page 75. Request letter dated 20th September 2025, which supports this letter dated page 69.
Yes.
Page 69 is a request to that your request is under process. Request for resignation withdrawal is under process. Now, as a sequel to page 69, if you come to page 75, there is the impugned letter.
yes,
It says the request letter dated 20th September 2020 submitted by so and so for withdrawal of his resignation repatriation has been duly considered. However, the request has not been acceded to by the competent authority. Does it not require assigning of reasons?
no. No, because I submit because he has waived his right by tendering resignation. Completely waived his
At the
right.
time, at the same time, Mr. Chakraborty, department has also waived its right based on the letter dated 8th of August 2025,
The
which
depart-
emanated in favor of the department.
Department's right, with great respect, I submit, is reserved to the authority to consider at a relevant point of time by giving the 3 months time and on consideration, and ultimately by 3 months time was given to him in the impugned order. Now
If that was the final response, 8th of August, what is the necessity to issue this email letter dated 24th October 2025?
But he has also referred to the other letters after the initial letter. In between, that is, if his lordship kindly comes to right from page 53 onwards. Yes, the approval of the competent authority is conveyed to us premature departation of Sri Subhendu Motilal, registered with effect from 31st August 2025. After completion of 3 months requisite notice period, a formal order of relieving the officer from the duties of the institute will be issued. This was a decision taken way back on 8th August, pursuant to his resignation.
Yes, that is the letter.
Yes.
If this is the letter, what was the necessity to write subsequent letter dated 24th October 2025?
That is a procedural
Yes,
matter.
that procedure is in terms of this page 65 circular, paragraph 3.
And with great respect, I again submit, kindly read once in the list, the circular. Circular does not give any right to a deputationist employee.
Yes, yes, but he is not a mere deputationist employee. It is an appointment on deputation, recruitment on deputation.
I have
now
not been able to satisfy your lordship on the distinction between a regular employee and a deputationist. Regular employee is governed by the service rules, and deputationist is governed by the TOPT rules. That is his terms of appointment. Because it is actually, there is no civil consequence, because he shall go back to his parent appointment.
but I am bound.
Case of termination.
But I am bound by paragraph 14 of Ashok Kumar Rotilal
No,
pattern.
I am showing to your lordship that deputation is no right at all.
Show me.
Yes.
Premature October.
Yes, before that, this is a Ministry of Department of Personnel and Training, which is governed in his appointment. It has been mentioned, Department of Personnel and Training.
Yes.
Para 11. Normally, when an employee is appointed on deputation, foreign service, his service are placed at the disposal of the parent ministry, department, organization at the end of the tenure. However, as and when a situation arises for premature reversion to the parent cadre of the deputationist, the service could be so returned after giving a notice of at least 3 months. Therefore, terms of condition is very much. This is given the right to us. He is bound by the terms of contract, and I do not. I am not obliged to give any reason. This is automatic. His condition of appointment on deputation says DOPT rules shall govern his appointment. And he himself is relying on DOPT rules. Where is the reason? Concept of reason and personal hearing comes only when there is a clear mentioning in the statute or a circular. Because no civil consequence is attracted in case of relieving him.
And withdrawal of resolution of central government servants আছে যত notification ওটা ট্রাই করছে
And you দাঁড়াও ওই জাজমেন্টটা দেখো সুপ্রিম কোর্টে সুপ্রিম কোর্টে
effort আছে
কবিতা
কিছু দেখিয়েছে
Mr. Bhattacharya,
Sorry.
consider this.
No, I have got something more.
Yes, I will hear you. I will hear. Mr. Consider this office memorandum dated 28 March 2024 of DOPT. Clause 11 says, give a copy to him. Yes. Clause 11 says, normally when an employee is appointed on deputation foreign service, his service are placed at the disposal of the parent ministry department organization at the end of the tenure. However, as and when situation arises for premature reversion to the parent cadre of the deputationist, his service could be so returned after giving a notice at least 3 months to the lending ministry department or organization and the employee concerned.
The clause is beginning with normally.
Premature reversion of
Normally is the case. It is not.
what is troubling this is that this appointment letter is of 3 years. That is creating difficulty.
Please, kindly falls back to the advertisement.
Yes, I'll hear you. Yes, Mr. Chakraborty.
Now, I'm not Department of Personnel Training. Now, about Department of Personnel and Training, your Lordship has some experience, and I have also gathered experience. I'm just making my submission. What is the role and function of Department of Personnel and Training? This is a department of the Honorable Prime Minister's Secretariat who are issuing notifications for IAS, IPS, central cadres, and IFS. Now, it has a distinction. Suppose one IAS officer or an IPS officer is serving the state government, he is governed by the state government rules. Once an IAS and IPS officer is serving the Home Ministry, he is governed by the Home Ministry rules. The CBI officer, when serving as central agency, he is governed by DOPT rules. And when an employee is serving the government of India, he is absolutely governed by DOPT rules.
Yes, and
He cannot switch over to any other question of law. He has accepted in terms of the appointment that his service shall be governed by DOPT rules. Now comes the moot question, which he has not been able to. His resignation letter does not disclose that in view of non-consideration of his repeated representation for payment of certain dues and interaction between the original parent appointed
parent employer.
Yes, he is tendering resignation. What is the cause of this tendering resignation has been disclosed. Had it been so, we were in a position to give reason to that issue. He has simply tendered resignation. He has simply thereafter saying so many representations. And then it was accepted. And then he is coming before the court. And after when he is relieved, he is not challenging that order of relieving. By supplementary affidavit, he has just brought it to your lordship's notice. He is not challenging, his prayer is not amended. Now comes the third question. That is that the Kerala High Court had the occasion to decide exactly this issue, and there the Supreme Court judgment has deferred to the paragraph. Para 18, kindly see. Concept of repatriation is inherent in a concept of deputation. Para 18, have your lordship got it?
Yes.
Yes. Concept of deputation is inherent in a concept of deputation. That is exactly in terms of the DOPT provision. Para 11. As long as the deputation has not been permanently absorbed in the borrowing department, a deputationist does not have indefeasible right to continue in the borrowing department. Repatriation can be resorted to on the ground of unsuitability or unsatisfactory work as long as the reputation of the petitioners does not amount to reversion of imposition of penalty and as long as the decision is not vitiated by bias, the petitioners cannot have any legal grievance in the matter. Now it has been referred to Supreme Court judgment.
Just a minute.
Para 19. This has referred to Supreme Court judgments. Para 19. The law relating to deputation is
Paragraph
well settled.
19.
19. Para 19. The law relating to deputation is well settled now. A deputationist does not have an indefeasible right to insist his continuance in borrowing department when his service is no longer required in exigencies of service. In such and such, the Honorable Apex Court held that a deputationist can be reverted to his parent cadre at any time. In Kumar number such and such, the Honorable Apex Court held that the basic principle underlying deputation itself is that the person concerned can always and at any time be repatriated to his parent cadre to serve in his substantive position at the instance of either of the departments, and there is no vested right in such a person to continue for long or to get absorbed in the department to which he is deputed. This principle
But
of law,
Mr. Chakraborty, Ashok Kumar Rotilal Patel has not been considered by the single bench of the Kerala High Court. It's a single bench judgment of Kerala High Court, and this Ashok Kumar Rotilal Patel has not been considered.
no, it has not been considered.
Yes,
But the
in an old
IR
judgment of 1990, and I am this judgment which this court is referring to, it is of 2012 7.
I have submitted before your lordship that on the basis of DOPT's circular, which is binding upon him, para 11, we can take the decision. And this DOPT circular has also not been considered by Ashok Kumar or Supreme Court. That even if this is there, he has a right. The general formulation of principle will not bind us on under Article 141.
Why you are saying that this page 65 is not applicable in case of the petitioner? This circular, which
65.
petitioner relies upon, page 64.
That is for central government employees for in case of pension rules, not deputation at all. It is not related to the employees who are on deputation. Withdrawal of resignation of central government servants appointed after 31st December 23 covered under the national pension system. Absolutely a different question and
But
memorandum.
it is on resignation.
Yes,
Resignation from service procedure in respect.
in respect of a permanent employee of the government of India. The headline says withdrawal of resignation of central government servants. Therefore, on a given facts, which I have initially submitted, that if it is different on the slightest question, there will be a sea of difference. No Article 141. Thirdly, the concept of continuous representation, which has been annexed in the writ petition. Simpliciter, what it reveals? It reveals so many questions. My question was not considered our payment. My resignation is under consideration. Can he approve and reprobate? What is his conduct? He could have initially challenged the order of releasing him in August 2024. He has not done so. He has accepted it. He has tendered resignation, withdrawn it confidently after a long time. And therefore, on a given facts of this case, whether he is entitled to an interim order, and he is at best can be entitled to consideration simplicity of his representations, which are so many representations are made. And since he is relieved on a consideration from August, if your lordship grants an interim order, what is the principle of law? That your lordship will be, somebody has taken charge in the post of register. What will be the principle of law? Your lordship is aware, I need not repeat. that at the interlocutory stage, no status quo ante or identity mandatory order can be passed. It can be adverse affidavit. And no permanent vacancy shall be filled up. Somebody, the additional Otanu Kumar Datto is in charge now of the registrar. Therefore, also the DOPT rules cannot be challenged because he has accepted the terms of condition. DOPT rule is binding. We have acted on that. It does not speak of giving reason. It is simplicity my right to terminate. It is terms of condition says within this period of 3 years or until further orders. We have exercised until further orders. And had it been a case simpliciter that he has not tendered a resignation, we have not asked him to resign. He has not tendered a resignation, and he has been driven out without anything. It could have been otherwise. He himself has tendered resignation, and now he is trying to approve it and reprove it. Conveniently comes to the court to apprise the Honorable Court that his case was not considered. And finally, your lordship is aware, in such a case, what are the case made out in a series of representations? One time,
Kerala case, which you are referring to, yes.
no, I am not referring to Kerala or Supreme Court at all. I am now confining my argument to DOPT circular, which binds him. Which binds him. He cannot get out of this because he himself has said it is a contract. Contract is under the DOPT rules. DOPT rules provide we can terminate. We have terminated. There is no provision for reason. He has not challenged this. He cannot challenge this because he is bound by these terms of appointment. And finally, what is the conduct? After tendering resignation, what happened? Series of representations on different count. And kindly also visualize, after acceptance of the resignation, he has come to the writ court. Finally,
But subsequently there was a letter that we are processing your request.
that is in
What was the necessity of
that
that
was-
processing of
you
request?
know, that is a necessity. There are departmental procedures in a Government of India organization. File moves from one department to the
In
other.
8 August was the final order regarding consideration of or which relates to resignation. What was the necessity of issuing this subsequent 2 letters? One is at page dated
Dated?
one is dated 24th October 2025
Or page.
and the page 69.
69.
Yes,
Yes.
this email letter.
You know, these are pursuant to his repeated representations.
October also.
If I want your lawsuit to go through the representation, how many representations he has made?
This is troubling this court
No,
also.
no, this is a case also goes against him because on repeated representation, if we act and communicate it to him, shall it not be deemed to be an opportunity of hearing was given? Supreme Court has said principle of natural justice will not apply in each and every case. If there is a communication and a public relation, the concept of principle of natural justice goes. And finally, if one point or the other is taken time and again the representation, he is absolutely barred under Section 41 of the Specific Relief Act to get an interim order. Because the law is formulated for the first time about the comprehensive injunction, not in Order 39 Rule and 2 Civil Procedure Code, but in Section 41. If his conduct is questionable, he is not entitled to interim order. Mr. Justice S.B. Sinha and Mr. Justice Sirpurkar as bylaws there were. Possibly, I remember I have referred to so many cases. 2008 volume.
But
11
where it is, where the conduct is questionable.
because
You have not
his-
initiated any
his
proceedings
conduct is-
against the
he
petitioner.
he is working in a responsible post. He is tendering resignation, writing so many letters. Does it not amount to conduct of a registrar? 4th October 61. And 4th, kindly come to page 61 also. In partial modification of official order number such and such, the undersigned is directed to convey that the repatriation of Sri Subhendu Material Registrar on deputation to his present is on his own request. Facts are completely different from the ratio.
Thereafter, he keeps on giving representation if we don't.
We have
consider
taken a decision on at page 61 on 4th October 2025.
তারপরেও 23rd
And what is the
23rd এ আবার দিচ্ছে যে ভাইলেশন আছে ন্যাচারাল জাস্টিস, তাই আমরা একটা
and he is repeatedly asking for violation of principle of natural justice. That is why we are communicating. Section 50, kindly once in the list, see section 41. If there is an alternate of the specific relief act. Before that, there is also a provision that injunction shall be refused if there is any other remedy. If he is aggrieved, he can prefer an appeal before the Secretary, Department of Personnel and Training.
Yes, Mr. Chakraborty, complete.
Section 41 of the Specific Relief Act. 41. Section 41.
It is relating to refusal of injunction.
Yes, that is I am submitting. That is not entitled to get injunction.
This court is contemplating to pass a final order. Yes. Yes, Mr. Bhattacharya, anything, have you completed?
Yes. No, I am. Huh? No, your lordship is intending to pass an interim order.
No, final order.
Final order. My lord, final order. Affidavits, possibly in a given facts of this case, maybe.
You want an affidavit?
My lord, if your lordship wants to dismiss, I have no objection. But if your lordship wants to set aside, I shall have to file affidavit.
Where you will file it affidavit, then I have to injunct this order at this stage. Yes. Anything more?
Yes. No, kindly record my submission.
Yes, yes.
তুমি বলে দাও। বইটা ছিল, আমার বইটা কোথায় গেল?
Affidavit of service filed on behalf of the petitioner is taken on record.
No, kindly once in the list check whether the the officer who is made a party by name,
Whether he has been served
he
on
has been received. Yes.
affidavit of service, I mean, whether that officer who has been arrayed by name has been specifically served on.
Yes.
Show me. এই দেখো দাও তো এভরি সার্ভিসটা।
An email. Well, as my lord.
What is the email document? No, this sort of submission will not do.
Mr.
Initially, I
Chakraborty,
took,
sir, sir, he
initially-
will not say something which is not borne out from
I am
the
not
records.
talking to you. I am not talking to you. I am addressing the court.
Sir, why are you making this submission?
To
An
addressing the
email,
court.
email is not applicable. What is
No, under the
applicable?
rules, it is not acceptable. Where is that document of email you have served?
Sir, it is there with the my lord's court.
Rule 26 has not been amended.
Sir, আপনি আছে এখানে।
বার করো তো।
Should I mark it with a pencil, that email, or
No, no, just find out.
No,
this one? Eiটা দেখান Joseph. Moyuk Pal.
Which respondent, Mr. Chakraborty?
Four. কি নাম?
Mayuk Ranjan Pal. Email service, I also do not accept. Mr. Bhattacharya, at the beginning of this,
Sent by post also.
when
Sent by
show me that service is complete.
post party.
Because this was pointed out by Mr. Chakraborty at the beginning. Then Mr. Bhattacharya submitted, yes, service is complete.
Yes, and respondent number 4, there is email ID has not been given. Then how was it served? Wrong submission was made.
আমার দেখতে দাও, admit দাও না।
Let me satisfy myself whether the service is complete or not.
Postal receipt টা শুধু আমাকে দাও না। Postal receipt টা বার করো, তাহলে ময়ূক রঞ্জন হচ্ছে 591. Just give me a second, minute. 591 track report. এক সেকেন্ড দাঁড়াও। Moyuk Ranjan has received mail earlier in the same email at page 68. So we have sent him email.
Where is the service hard copy of the
Yes.
petition where you have
Yes.
served?
Lord, this is the page 7, Moyuk Ranjan, parcel is sent. Now, my lord, the track report, আরেকবার দেখ track report টা এখন 591, এটা নাম্বার হচ্ছে, ছবি তুলে নে দেখ। কি করারই তোকে দরকার নেই। 591, just give me a second, Lord, just give me a second. 551, 591. Lord, it was item booked on 1st November, 31st October, 2nd November, 3rd November, item in transit, 3rd November, item bagged, Gospara, item received, Ranaghat, item dispatched. The last entry, that is of 3rd of November, is here. এখন চেক করলে পাওয়া যাবে, দেখো বার করো। We're just checking it, not when we affirm the affidavit till it was sent, not it was reached the local post office. That's the last entry.
And all communications have been
Sometimes-
received by us from email.
Sometimes email, sometimes postal service.
So
No, both. We have done both.
So why the union is taking that point? Why the union is taking that
Please,
point?
please do
This is
not
a
try
point
to
be
teach me
taken.
the question of law.
Nobody is taking-
Whenever you are making somebody a party, learn the law.
Nobody is
I will
taking-
not learn the law from
Yes.
you, sir.
Yes,
We have learned the law outside, not here.
yes.
My lord,
Whenever,
we have served both by email as well as by registered post with review. If the ministry's, my lord, postal records do not reflect, that is not my problem. I cannot, my lord, address something beyond records.
once somebody is made a party by name,
My lord,
the
delete him.
allegation of.
Kindly delete him. My lord, Mr. Chakraborty is representing AIIMS,
Delete
not
him.
Mr. Mayuk Ranjan. My lord, kindly
No,
delete
no,
Mr. Mayuk Ranjan Pal.
Allegation of bias is
There is no
there.
question of
Affidavit of service filed on behalf of the petitioner is taken on.
এটা কর।
Next file.
May I kindly also record that a person has taken charge of the post of registrar. His name is Otanu Kumar Datto.
Not after receipt of the copy by email on 31st, after
Very well,
taking leave.
this is submission.
They paid for time yesterday. They did not disclose this.
They will not,
Yesterday.
yes, day before yesterday, they paid for time.
Yesterday, union paid for time. They did not disclose this. This is deliberate.
No, somebody else was appointed.
Mrs. Pandey was there in the morning. Why it was not
Can
disclosed?
be done, Mr.
Why
Chakraborty.
it was not disclosed?
Priyanka Tibrewal,
Your
Priyanka Tibrewal was
time last occasion.
Why it was not disclosed?
Priyanka Tibrewal was engaged from the Ministry of Law. She did not appear. I had to take over this and engage Amrita Pandey to appear before your lordship today.
No, Miss Pandey appeared on
Last
day
date was
before
a-
yesterday.
Yes, because she was not appointed.
She prayed for time to obtain
Lord,
instruction.
yes.
And in the meantime, this
Lord,
department
may I just say one
when he
thing?
has joined Mr.
No,
Chakraborty.
not regular appointment. He's in charge, taking charge.
Lord, only one information to your lordships, my lord. Kindly have a look at the last day's order, your lordship's order. Kindly see, read para 3. Miss Pandey appearing for respondent number 2 to 4. So appeared for the private party and today said the copy not received. Your junior appeared.
But for not copy received, yes, not that.
এই
police
শুভেন্দু
officer.
আছে না?
Sir,
করেছেন চারের হয়ে,
sir,
দেখুন
appear
আপনি appear করেছেন।
মিথ্যে কথা বলবেন
চারের
না,
হয়ে
sir,
appear করেছেন, স্যার। তারা three দেন। তাহলে তোমাদের problem, তুমি জানতে না পারো।
পারফরমেন্স আমি জানি না, নতুন ছেলে।
For aims.
2 to 4,
শুভেন্দুকে ডাকো।
2 to 4 এর হয়ে appear করে এখন বলছে 4
আমি
কপি
তো
পাইনি।
for aims of
এটা কি করবো?
ঠিক আছে, আমি তো জানতাম না কার কি আছে।
ঠিক আছে, ঠিক আছে।
রণজিৎ কোথায় চলে গেল?
Lord, may I leave?
ইয়েস,
May I leave?
after
Just দেখেছো আমার?
না, না, অন্য কোর্টে মামলা আছে।
after আমার সাথে মারপিট তোমার অপরাধ কি? কিসের অপরাধ?
বলো
এটার ভেতরে কোনো অপরাধ নেই।
ডাকছে।
যা ইচ্ছে করো।
শুভেন্দু নেই,
যেতে হবে।
আসবে না আজকে? তাহলে রণজিৎকে ডাকো, রণজিৎকে ডেকে নিও। হ্যাঁ, তুমি নাও ততক্ষণ, যেখানটা বুঝবে না একটু বলবে।
মারপিট করে ঝগড়া করে
এই তো ভালো আমাদের
আমার জানা নেই।
আমি বরদাস্ত করে নেবো।
সব থেকে
In the writ petition, comma, inter alia, comma, কেটে দাও, in the writ petition কেটে দাও.
এতে পুরো লেগুপতি গভর্নমেন্ট
It is submitted by learned advocate representing the petition that a vacancy notice on deputation dated 23rd September 2023 was issued to fill up the posts as mentioned in the said notice. On behalf of All India Institute of Medical Sciences, Kolani, for within bracket for short, AIIMS, Kolani. So, in the said notice dated 23rd September 2023, it was indicated that post of registrar to be filled up. And eligible candidates were invited to submit applications in prescribed form. From eligible officers of central / state government / UT / autonomous bodies / universities / public sector undertakings / R&D organization / police departments of central, state, UT, etc. এটা না পেজ 29 ইলাবোরেশনটা পেয়ে যাবে দাগ দিয়ে। Petitioner, you know, participated in the selection process, and was appointed. Now, and on being selected was appointed as registrar of AIIMS Kollani. Appointment letter dated 16 July 2024. Stop. Petitioner was released by the registrar within bracket acting close bracket of Uttorbongo Krishi Vishwavidyalaya, as he was working as assistant registrar and joined post of registered in AIIMS Kollani on 1st August 2024. Stop. While discharging 1st August 2024. Stop. While discharging duty as registered AIIMS Kollani, dispute arose relating to depositing leave salary contribution, comma, deputation allowance, dearness pay, comma, ad hoc pay, comma, personal pay, etc. লাস্ট সেন্টেন্সটা কি বললাম, ছোট বলছে না, dispute বাকিটা কেটে দাও। Dispute arose relating to leave salary and pension contribution relating to petitioner, which led to tendering resignation by the petitioner via letter dated 26 July 2025. In the resignation letter dated 26 July 2025, it was also stated that notice period was applicable with effect from 1st August 2025. Stop. Subsequent thereto, on behalf of AIIMS Kolani, video office order dated 8 August 2025. It was informed that approval was accorded for premature repatriation of the petitioner with effect from 31st October 2025. Stop. It was also stipulated in the said office order dated 8 August 2025 that a formal order of relieving the officer or relieving the petitioner from the duties of the relieving the petitioner would be issued in due course after completion of formalities. Next paragraph. Subsequent next paragraph. Subsequent thereto, petitioner recanted and submitted a letter dated 20th September 2025 before the concerned authority of AIIMS Kolani, intimating that letter of resignation, intimating that his letter of resignation could to be treated as ineffective and withdrawn. Stop. According to the next paragraph, according to the petitioner, said letter dated 20 September 2025 was acted upon by the concerned authority of AIIMS Kalyani and video email letter dated 24th October 2025. It was intimated to the petitioner that letter of the petitioner intimating withdrawal of resignation was under process and the decision to be communicated to the petitioner shortly. Ultimately, with a impugned office order dated 27th October 2025, a request of the petitioner or letter of the petitioner dated 20 September 2025 intimating withdrawal of resignation was negated and it was further intimated to the petitioner that he would be relieved with effect from 31st October 2025. Next paragraph. Said office order dated 27th October 2025 is questioned by the petitioner and reliance is placed on office memorandum dated 11th February 1988 issued by the Joint Secretary to the Government of India relating to resignation from service, where letter issued on behalf of AIIMS Kalyani or email letter issued on behalf of AIIMS Kalyani dated 24th October 2025. Huh. 24th October 2025. In reference to paragraph 3 of said office memorandum dated 11th February 1988, it is submitted that concerned respondent authority needs to decide. Needs to decide on the request letter of the petitioner seeking withdrawal of resignation assigning reasons in the event such request is refused. Stop. It is submitted. Stop. It is further contended that impugned letter dated impugned office order dated 27th August 2025 is bereft of reasons. Petitioner prays for setting aside of the office order dated 27th October 2025, setting aside of the office order dated 27th October 2025, thereby permitting him to function as registered AIIMS Kalyani in terms of the appointment letter dated 16 July 2024. Next paragraph. Mr. Ashok Kumar Chakraborty, learned additional Solicitor General, appears on behalf of AIIMS Kalyani and has opposed the prayer of the petitioner. Relying upon appointment letter dated 16 July 2024. Stop. According to the respondents, in terms of the said appointment letter dated 16 July 2024, petitioner was appointed on deputation initially for a period of 3 years from the date of assuming charge, and said appointment letter dated 16 July 2024 also intimated the petitioner that tenure of deputation service would be regulated as per DOPT, D এর পরে ওটা ছোট তারপর PT capital guidelines. Stop. In order to buttress the case made out on behalf of respondent authority, office memorandum dated 28 March 2024 issued by Undersecretary to the Government of India, Ministry of Personnel, Public Grievance and Pension, Department of Personnel and Training is relied upon, containing clause 11, wherein it is provided premature reversion of a deputationist or premature reversion of incumbent on deputation. Premature reversion of an incumbent on deputation to the parent cadre in an appropriate situation. Requires only take it, the requires tendering a notice of at least 3 months to the lending ministry or to the lending organization and the employee concerned. Next paragraph. According to the respondents or respondent authority, petitioner's appointment was for a period of 3 years on deputation. And in the event petitioner is relieved of his relieved of his and in the event petitioner is relieved of the post held by the petitioner on deputation, compliance of clause 11 of Office Memorandum dated 28 March 2024 is sufficient. It is also submitted that after tendering resignation on 26 July 2025, when same was accepted via office order dated 8 August 2025, no further formality was required to be considered, and apparently there is no flaw in the impugned or no flaw in the office order dated 27th October 2025. Next paragraph, it is also submitted that during pendency of this writ petition, the person has taken charge as registered AIIMS Kolani. Stop. Next paragraph. On behalf of respondent authorities, reliance is placed on the judgment of a coordinate bench now on the judgment of the Honorable Single Bench of Kerala High Court dated 22nd March 2023, in the writ petition being WP within bracket capital C close bracket number 8235 of 2023 within bracket Ajin K AJIN Ajin K full stop A full stop and others versus the Joint Deputy Director Bureau of Immigration and others. Next slide. In considering submissions made on behalf of the parties and facts of the present case, it appears that petitioner was appointed as Registrar AIIMS Kolani in terms of the appointment letter dated 16 July 2024 and joined on 1st August 2024. Stop. Albeit, it was pointed out on behalf of the respondent authorities that petitioner was appointed on deputation for a period of 3 years from the date of assumption of charge. But it is not a case of relieving the petitioner. Based on an independent decision taken by the respondent authority. Stop. Rather, question of relieving the petitioner, rather question of repatriating the petitioner to his parent organization cropped up due to resignation letter dated 26 July 2025. Initially, respondent authority responded to the said resignation letter dated 26 July 2025, video office order dated 8 August 2025. But prima facie, it appears that contents of office order dated 8 August 2025 was not final decision of the respondent authorities. In view of issuance of subsequent letter dated 24th October 2025, email letter dated 24th October 2025, whereby petitioner was intimated that his request to withdraw resignation was under process. Stop. Hence, it appears that on the date of issuance of email letter dated 24th October 2025, issue was kept alive, which culminated into impugned office order dated 27th October 2025. Clause 11 of DOPT, Clause 11 of Office Memorandum dated 28 March 2024 of DOPT does not relate to, does not contemplate a situation where incumbent, after tendering resignation, decides to withdraw the same. Therefore, at this stage it appears, therefore, at this stage, while considering grant of interim protection to the petitioner, court finds it apt to rely upon Office Memorandum dated 11th February 1988, Clause 3, which deals with a situation which is present, which deals with a situation as found present in this case. Clause 3 of Office Memorandum dated 11th February 1988 provides in case of refusal of request to withdraw resignation, authority is required to assign reasons. In the case at my hand, final order of refusal to accept withdrawal of resignation as made by the petitioner, as prayed for by the petitioner or as requested by the petitioner, comma, which is in the form of office order dated 27th October 2025, is devoid of reasons. Stop. Next paragraph. Court is inclined to rely upon paragraph 14 of the judgment, paragraph 14 of the judgment of Honorable Supreme Court reported in 2012 7 SCC 757 within bracket Ashok Kumar Rotilal Patel versus Union of India and another. So paragraph 14 is quoted below. Paragraph 14 is quoted. Next paragraph. On the contrary, in Ajin K.A. Supra, AJIN, Supra is Kerala High Court judge. In Ajin K.A. Supra, in paragraph 18, it was observed that a deputationist does not have indefeasible right to continue in borrowing department, comma, repatriation can be restored, repatriation can be restored to on the grounds of unsuitability and satisfactory work. Stop. In the present case, authority, concerned respondent authority has not decided repatriation of the petitioner to its parent, to his parent organization, having found the petitioner not suitable. Rather, issue is whether request of the petitioner to withdraw resignation letter is to be accepted or not. Borrowing inspiration from paragraph 14 of Ashok Kumar Rotilal Patel Supra, court finds simply because petitioner was recruited on deputation for a period of 3 years, from the date of assuming charge, he can be relieved at any point of time within the period of 3 years, or he can be repatriated at any point of time within a period of 3 years based on resignation letter of the petitioner which was subsequently withdrawn. Stop. It needs to be taken into consideration that office order, that impugned office order dated 27th October 2025 did not disclose any reasons of not accepting request of the petitioner to withdraw resignation letter. Next paragraph. In view of aforesaid consideration, this court finds it apt to stay the office order dated 27th October 2025 and 2025 for a period of, or 2025 till 30th January 2026 or until further order. Stop. Respondent shall be at liberty to file affidavit in opposition to this writ petition by 3 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Stop. Next paragraph. Parties shall be at liberty to mention the matter for hearing before the appropriate bench after the time fixed herein above for exchanging affidavits. এটা লাগবে না, এটা দিয়ে দাও, এটা এফিডেভিট অফ সার্ভিসের সঙ্গে থাকবে। ধরে করুন দুজনে মিলে, রণজিৎ সেট করে কেটে গেছে।
Item number 2.
Item number 2, my lord, I am for the petitioner, my lord.
My lord, I'm for the respondent number 2, 3, and 4, LICI. My lord, we are still waiting instructions from our client.
My lord, may I just, my lord, place the case, my lord? My lord,
My lord, we shall come
Huh?
back with affidavit in opposition on the next
দুই
day.
থেকে 7
Mm, My lord,
lord, the-
kindly keeps it on Monday.
my lord, there's one urgency, my lord, I'll
Keeps it on Monday.
really accept.
My lord, I am for the respondent number, item number 3. I have not been served a copy of the petition.
My lord, the urgency is, my lord, the Life Insurance Corporation of India has, my lord, issued a show cause notice to the petitioners. Now, my lord, in respect of the show cause notice, the service of the petitioner is to be terminated in view of, my lord, the rules framed by the Life Insurance Corporation of India, my lord, in 2009 and subsequently amended in 2016. Now, my lord, a similar matter, my lord, was placed before your lordship on Monday, my lord. Your lordship has there was an interim order, my lord, by the coordinate bench. Your lordship has, my lord, fixed the matter for hearing in the month of, my lord, January. Since, my lord, the issue right now is pending, my lord, before the Honorable Apex Court, my lord. After, my lord, the Allahabad High Court has already, my lord, held, my lord, that the rules are inter-vires. That is, my lord, the issue. And, my lord, this next step, my lord, is the... My lord, in item number 2, I can wait. My lord, item number 2 to 7, my lord.
My lord. My lord, item number 3, I am for the LIC. We have not been served with the copy of petition. May it be served. upon-
Item number 3.
For my lord, ECL, Instant Coalfield Limited.
না, 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 ECL এর ব্যাপার না, ECL এর ব্যাপার।
My lord, we have not been served with the copy yet of the
Not
petition.
the LIC has been served with a copy. Yes, yes. The department has served.
My lord, kindly it be served again because we have not received the copy. My lord, similar orders in item number 5 and 7.
Item number 4.
উনিশ টাকা কত নম্বর থেকে?
My lord.
My lord,
No, my lord,
same issue involved. My lord. My lord, this is. My lord, let it be, my lord, because, my lord, the matter is pending before the Supreme Court. I have told, my lord, the matter would be taken up for hearing on 17th of November.
my lord,
Same
24th,
issue.
24th of November. My lord. I've got the copy of the order, my lord. 24th of November, the matter. My lord, the difficulties, my lord, the interim order, without an interim order, my lord, the next step is the termination notice. A 30-day period, my lord, is, my lord, provided to the, initially, my lord, a show cause. Initially, my lord, a show cause has been served. The development officer of the, yes. But with the rules, yes, my lord, may I, my lord, only, my lord, show your lordship, my lord, from one of the petitions, my lord, the rules, my lord, once. Sir, এটা কোনটা?
My lord, what?
Sir, এটা কোনটা?
এটা হচ্ছে
রাজা ডাকুয়া।
Raja Dakua. My lord, yes, this is the issue, my lord, where already interim of order was passed. My lord,
By this court, by
by this honorable court, by several other high courts also, coordinate bench of. Now, my lord, now the.
what was the nature of interim order which was?
Not to take any further step, not some in connection with the disciplinary process, not disciplinary, my lord, in connection with the show cause notice. Lord, they are the development officer, and while appointing them, my lord, there is a target. You have to give this business, and your
where a cost ratio will not go beyond certain percentage. All right, they have failed. Now, Lord, the LIC has given several opportunities. Now, Lord, the issue now is against Allahabad High Court. Allahabad High Court has held in favor of the Life Insurance Corporation of India, and Lord, virus of Rule 5 and 7 of the Life Insurance Corporation has been challenged. So, my Lord, now the matter is pending before the Honorable Supreme Court. I am told, my Lord, 24th September, it will be heard. So
in the meantime, do not take any steps against the, based on the show cause notice, because this court has already passed an order.
Already there are several writ petitions.
So if you can submit that for a period of 1 month or for a period of 8 weeks, no steps to be taken on show cause, then I can fix the matter in the month of January.
No, my Lord, one thing, my Lord. Only the LIC would be entitled to proceed further. In all earlier interim order, there was an order that will go on proceeding.
Proceed, but not to pass final order. Where is such order?
Already.
Yes, my lord. My lord, many of the orders, my lord, annexed with the writ petition, my lord.
Yes, sir.
My lord, in this item number, page number 84.
48, 46.
My lord, may I just, my lord, place the crux of the matter, my lord, in a very...
No, just a minute.
My lord, certainly.
My lord, kindly takes up.
Page 84, my lord. অন্য মামলাটা হচ্ছে জানুয়ারিতে রেখেছে।
কোথায়?
না অন্য মামলা, একটা সোমবার হয়েছে।
এখানে আগে আরো মামলা হয়েছিল। ও ওইখানে হয়েছিল
সোমবার দিন একটা হয়েছে।
সোমবারে ওটা জানুয়ারিতে রেখেছেন। ওরা কপি আছে তোমার কাছে?
অর্ডারটা 4 নম্বর যা করবো
আমাকে আবার
হ্যাঁ 2444 স্ক্যান কপি বোধ হয় এটা না?
বলে এই রাজা ডাকুয়ারি বোধ হয় চিনি।
তো 46 প্রেজেন্টেশন মিলছে তো একটু। আমি রিলাই করছি
84 আছে।
সিমিলার অর্ডার।
সিমিলার। কালকের অর্ডারটা তুমি পাওনি আপনার? আচ্ছা দাও না আমাকে, যতটুকু দিয়ে দাও।
একটাই কপি আছে হচ্ছে।
তাই সেইটা দেখাও।
ওইটাতে ইন্টারিম অর্ডার ছিল, ওটাতে শুধু জজ সাহেব ইন্টারিম অর্ডারটা পড়ে ওটাকে মান্থলি লিস্টে ফিক্স করেছে।
ও এই ব্যাপার।
Situation remains unaltered as it emanates from the order dated 10 July 2025. So there is no scope for passing any different orders in view of the order passed by the coordinate bench is not appealed against. The order of the coordinate bench is dated 10 July 2025. And the special leave petition which is pending before the Honorable Supreme Court, that is 6366/2025 is still pending.
Yes, my lord, here's the last order.
কপি দেবে
Inter copy, sir.
একটাই কপি
Copy, please. Sir, বাড়ি গিয়ে করে দিচ্ছি আপনাকে।
Where is the show cause notice?
Page 50.
508
My lord, page 50. After that, my lord, my reply. At my lord, page 52.
Page 50 is a show cause notice.
Yes. Rajaratna supplementary.
This is show cause notice is 14 July 2025. Page 50.
Yes, my lord, it was received on 28th of July, my lord. The next page, my lord, I've endorsed. And my lord, my reply is, my lord, dated 11th of August, within the time frame.
Sure. Matter is heard in presence of the filed affidavit service. Affidavit service filed on behalf of the petitioner is taken on record. Stop. Matter is heard in presence of the learned advocates representing the petitioner and Life Insurance Corporation of India within bracket for short LIC close bracket. Stop.
One.
Next paragraph. On perusal of writ petition, it appears certain rules of Life Insurance Corporation of India, Life Insurance Corporation of India development officers within bracket revision of certain terms and conditions of service close bracket amendment rules, 2016 are prayed for. Certain rules are certain rules of so and so of 2016 are questioned and declaration is sought for. And prayer is made to declare those rules ultra vires. At the same time, proceeding initiated against the petitioner being the development officer.
Yes, yes.
The petitioner being the development officer by issuing show cause notice dated 14 July 2025 is also questioned in this writ petition. Next paragraph. During course of hearing, reliance is placed on the order passed by a coordinate bench on a writ petition being WPA 547 of 2025 within bracket Surojit Ghosh versus Union of India and others. ডেটটা বলেছি দেখো তো 10 July. Reliance is placed কি বললাম on the order of a coordinate bench passed on WPA so and so within bracket so and so dated 10 July 2025. Stop. Next paragraph. On perusal of the said order dated 10 July 2025, passed in Surojit Ghosh Supra, it appears that coordinate bench taking note of the observations made by the Honorable Division Bench in an appeal, in an intracourt appeal being MAT 1222 of 2024, touching upon similar issue, and in view of pendency of a special leave petition being special leave petition within bracket civil close bracket diary number 6366 of 2025 within bracket Hitesh Kumar Goel versus Life Insurance Corporation of India and others, passed interim order. Passer again a comma দেবে. Passed interim order thereby directing that proceeding initiated against the petitioner may continue, but no final order to be passed by LIC. ওপরে লাইফ ইন্স্যুরেন্স কর্পোরেশন অফ ইন্ডিয়া তারপরে না ব্র্যাকেটে ফর শর্ট LIC করবে, ক্লোজ ব্র্যাকেট. Next paragraph. Learned advocates representing petitioner and LIC submits to date that the situation remains unaltered as on date in view of pendency of the issue before the Honorable Supreme Court. Stop. Order passed by Honorable Supreme Court on 29th August 2025 in Hitesh Kumar Goel Supra is also placed before this court and same is taken on record. Next paragraph. Next paragraph. In consideration of aforesaid, next paragraph. Hence, concerned authority of LIC is directed. It is clarified that concerned authority of LIC may continue with the proceeding initiated against the petitioner, but no final order to be passed. But no final order shall be passed. Stop. List the matter under the heading motion in the monthly combined list of February 2026.
Item number 5.
5, my lord, I am for the petitioner.
Same issue.
Same issue, my lord.
My lord, we have not received the copy of the petition.
We'll come back on Monday. Not this week. Next.
Next up.
Item number 6.
6, my lord, I am for the petitioner, my lord.
Who is for LIC?
6 মানে copy has been served.
We'll come back on Monday. Along with those matters, it will be taken up. Not this week.
Item number 7.
LIC.
আচ্ছা একটা লাইন ওই অর্ডারটা অ্যাড করে দাও তো তারপরে party shall be at liberty to mention the matter for inclusion in the list before February 2026 if the situation is altered by virtue of the order of the Honorable Supreme Court.
হবে না তো 7 টা।
They'll come back at 2.
Item number 7 is also, she's also seeking a accommodation, my lord.
Not this week.
Not this week.
Not this week. Yes, call the list.
My lord, may I be permitted
Item
to
number
mention a matter? Mention a matter.
No, it's not even mentioning time. Yes.
8. Regarding this matter, we need time because of two reasons. We need instruction from CRPF. And number one, there is no urgency because the person is already returned on 31st of October 2025. Hope Himalaya will give a direction for affidavit, we will file the affidavit.
We are not getting, what is the urgency? Because this matter has come up under the heading.
Actually, the writ petition was filed at a time when he was still in service. But since there is a mandatory rule of 72-hour service, the matter could not be
Mandatory
taken.
rule of?
72 hours of gap between filing and service upon the Union of India. That's why the matter could not be taken up prior to 31st October. Now, the contention of the petitioner over here is that a promotion has been wrongly denied to him by downgrading his medical rating, medical category rating. He has been downgraded to Shape 2 in May 2025. Since May 2025, although there have been repeated representations on behalf of the petitioner to conduct a review medical examination, no such review medical examination has been conducted.
As a result, whereof promotion was denied.
Promotion, yes, he could not get the
So the
promotion.
benefit of promotion was not extended to the petitioner.
On the
And
ground that he
promotion
was-
is allowed not only the benefit during the tenure, last part of the tenure, but there is a possibility of consolidation of retirement dues.
Yes, pension in accordance
Yes.
with
Kindly see.
Are you in a position to argue or you want instruction? Mr. Rai Chaudhary, are you in a position to argue
No,
or
we are asking time from the beginning, I'm saying.
No. I will first. I will be here that if there is a necessity to file affidavit, then I will direct. Yes.
Then
yes, please.
Yes. My lord, the petitioner, he was working in the capacity of inspector ministerial. Now, back in 2023, 24th May 2023, my lord, his medical, physical
When
capacity.
petitioner retired?
Sorry, 31st October 2025, my lord.
Yes.
Yes, on 24th May 2023, my lord, his medical rating, especially in the category of physical capacity, was reduced to P2, downgraded to P2. Thereafter, my lord, he underwent review medical examination, and the review medical examination confirmed such finding, and his rating was kept at P2. Thereafter,
It was on downgradation.
Yes, the downgradation was approved in the review medical. Next, my lord, in 2024, in the annual medical examination, he was once again upgraded to P1.
P1.
Yes.
When it was this upgradation was made?
Yes, 2024, 12th March 2024.
Yes.
And now again in the year 2025, in the annual medical examination conducted in the month of May, 28th May 2025, he was once again downgraded to P2, which was almost 5 months prior to his retirement.
Yes.
Now, my lord, the standing orders applicable to all these situations where there is a medical examination and review medical examination, responsibility is vested in the unit or the establishment where the concerned officer works to conduct a review medical examination in cases of downgradation. If there is a downgradation, there must be a review.
Is there any circular in this regard?
Yes,
that
there is a
once he
standing
was downgraded on 28 May 2025, lastly,
My lord.
after within which period that medical assessment was required
My
to
lord,
be made?
may I place this standing order? They have referred to this standing order in one of the communications. Hence, I am placing this. Standing order SO 4 of 2008.
Yes.
কিছুই নেই, তুই যদি না দিস আমি দেখবো কি করে?
One minute, my lord.
So your case is that after downgrading the petitioner medically,
yes,
on 28 May 2025,
yes, my lord.
petitioner subsequently retired on 31st October 2025. So in between 28 May 2025 and 31st October 2025, there was a requirement of further medical assessment.
Yes, my lord, kindly comes to 5.
Is it your case?
Yes, yes. Because I had also applied for review medical, that you please review this finding of the annual medical examination. Now kindly comes to clause 5.2a. I have turned it to the relevant page, my lord. Has my lord found it?
Yes, yes.
Yes.
Just a minute.
Yes, my lord. Please, এক্ষুনি print out বার হয়েছে, একটু আগে। Madam, kindly sees in case of delay of more than 60 days prior approval of the medical officer in charge of the concerned
At the relevant point of time, did you make any prayer?
Yes, I have made representation.
After 60 days?
No, not after. My lord, kindly comes to page 30.
Today there is a difficulty. Difficulty is this, that there was no medical examination or medical categorization.
Yes.
As it was required to be done within the required to be done within a period of that is 31st of October 2025. You require, yes, within a period of 28 May 2025 and 31st of October 2025. But this was not done.
Yes,
this was not done,
my lord.
Now, what would be the result of categorization? That has a bearing regarding
My
taking
promotion.
decision of your regarding taking decision of
my
your promotion.
Yes.
Now, whether court today can proceed on the premise that had there been medical categorization, you would have been upgraded from P1 to P2.
No, my lord, kindly comes to page 33 once of the writ petition. my lord.
Which fact is this? I
appreciate.
appreciate your agony and your contention that yes, there was a requirement of medical categorization within this period, that is 28 May 2025 and 31st of October 2025. But this was admittedly, this was not done. Now, your promotion depends upon the result of medical assessment or medical categorization within certain time.
Yes.
So if today, as Mr. Rai Chaudhary has submitted that there ought to be a direction for maybe a direction for filing affidavits, unless the affidavits are called for, on what basis court will proceed? That it was a case of promotion based on medical categorization.
My lord, I appreciate, my lord. Kindly comes to page 33, my lord, of the writ petition. 33 and 34.
Yes.
Kindly sees this is a representation preferred by me on 24th of September, wherein, my lord, kindly comes to the on the subject matter, my lord. On the subject matter, it is submitted that on the basis of my application dated 30th May, addressed to the DIG, and 30th June, addressed to your good office, DIG Medical, vide his signal number such and such, dated 11 July, directed Commandant 167 Battalion for reassessment of my annual medical examination, review medical examination. On receipt of direction from Medical Officer 167 Battalion, I have completed all kind of prescribed tests on 5th August. Accordingly, as per direction, I have proceeded to Command Hospital BSF 11th August for showing my medical documents. But head clerk BSF kept my phone number intimated as and when the board is initiated, I may be recalled. Now, my lord, why they have referred to this board? Why the petitioner has referred to this what lends credence to the contention of the petitioner in this representation is that the SO that I have just handed over, my lord, in case of persons who are otherwise eligible for promotion, but have been downgraded, their medical examination has to be conducted by a special medical board consisting of a certain officers and individuals. My lord shall find that at page 35 of the writ petition. And before 35, my lord, kindly sees 34 once. Kindly sees 34. 34 sees, my lord, specialist, third line, specialist opinion from Command Hospital BSF, Kolkata / Medical College Hospital in R/number such and such, Bidhan Chandra Majumdar of this sector headquarter not yet received. This is 29th September. My lord, the contention is of administrative latches. Today I have been applying since May.
So why at that material point of time you did not move the court?
Yes, that is my fault, my lord. There may be because there is
After retirement, now you are in receipt of all retirement dues.
I have to seek
Now,
instruction.
yes, now today whether court can proceed on the premise and direct that yes, it was a case of upgradation medically, so far petitioner is concerned on medical categorization, and petitioner should be needs to be promoted unless and until an opportunity is granted to the authorities to file affidavit.
Only one.
Try to appreciate the predicament of this court, because your window of promotion depends upon medical categorization.
Yes.
Now, if that is not done, which was required to be done within that period, today, unless until this affidavit is called for that why this was not done, then if it was not done, whether any scope left open to consider post facto promotion of the petitioner, where is the scope so far this where is the avenue left open to this court to give a direction at this stage to promote the petitioner and give benefits thereof?
As regards my lord's query as to what is the scope, my lord, subject to correction, the writ court is has the power to restitute the petitioner. A constitutional court, if it
Without
finds
granting opportunity.
no, that is not.
So that's a, what
Yes,
that is
my
what
lord,
I am asking for.
yes. My
So you are working. You were working under which post?
I was
In
working
which
as
post?
inspector ministerial. Inspector ministerial. In the capacity of head clerk, legal branch. Since it is a ministerial post, non-combatant.
In Central Reserve Police Force.
Yes, CRPF.
Yes, sure. Affidavit of service.
My lord.
Affidavit of service filed on behalf of the petitioner is taken on record. Law and advocate representing the petitioner submits that had there been medical category, medical examination after 28 May 2025 and before superannuation of the petitioner on 31st October 2025, there was possibility that medical condition of the petitioner would have been upgraded from P2 to P1. Stop. According to the petitioner, stop. It is also submitted that on upgradation of medical condition of the petitioner from P2 to P1, petitioner would have been adjudged as an eligible candidate to get promotion to the higher cadre, to the next higher cadre, before his superannuation on 31st October 2025. Stop. It is contended that it is submitted that due to failure on the part of the concerned authorities of Central Reserve Police Force, medical examination was not done within the stipulated time, resulting in denial of promotion to the petitioner. Petitioner has retired on 31st October 2025. Next paragraph, Mr. Raichoudhury, learned advocate.
Is due to retire on 31st October. You filed this case on 28th of October before this court.
Yes.
In the affidavit part. My lord, his prayer in page 17, a mandatory injunction commanding the respondent authority concerned and the main agents assigned to conduct review medical examination. Now, it's not possible at all.
Mr. Raichoudhury, learned advocate, is representing respondent authorities who has prayed for opportunity to file affidavit. Stop. Next paragraph. Considering the issue involved in this writ petition, court finds calling for affidavit is required to adjudicate such issue. Next paragraph. Let affidavit in opposition to this writ petition be filed by 4 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits.
2 weeks, 2 weeks.
4 weeks, 2 weeks.
4 weeks, 2 weeks.
Let it be 2 weeks.
It will be rather I am asking for 6 weeks.
Take it. Next, item number 9.
I am for the petitioner.
এটা কি 8 হলো? এই এটা কোন ম্যাটার ছিল না, কবে আসার কথা ছিল সেটা কোন? না একটা 7 তারিখে না 8 তারিখে আসার কথা ছিল, আগে এসে যাচ্ছে অন মেনশন নট দিস উইক হয়ে বেরিয়ে গেছে। ঠিক আছে, এটা মোশন হলো, নিউ মোশন 1 8. Yes.
My lord, I am for the petitioner. My lord, petitioner is the employee of the Durgapur Project Limited. My lord,
petitioner is
employee of the Durgapur Project Limited. My lord, only paid for the interest over the gratuity and leave salary amount. My lord, coordinate bench of this honorable court has already passed several judgments. My lord, may I be permitted to place those, lordship?
Judgment will come later.
Yes, lordship.
You
lordship, kindly
place
come.
your case.
Page
You are
11.
employee of Durgapur Projects Limited.
Yes.
Now you are paying for interest on gratuity
and leave salary.
Well, actually, gratuity and leave salary we have already paid with interest. Now, due to effect of ROPA 20, additional gratuity and leave salary has been disbursed. Now, my largest Millard paying for interest against that amount.
No, my lord, this is not.
It is being delayed.
revised amount.
Revised.
On revised amount.
My lord,
Effect of ROPA 20. Well, some delay is there, but your lordships kindly consider Millard the
first 5 matter as not regarding to the ROPA. Last one is the ROPA.
তাহলে ফার্স্ট টাইম ম্যাটার কি?
First matter normal.
ওই তো সবই নরমাল নয়, অ্যাডিশনাল মানি হচ্ছে।
ফার্স্টের একটাও এমনি নরমাল।
ও নরমাল,
হ্যাঁ
আমি বলছি তো 5টা। আর কোনটা আছে রোপা?
রোপা লাস্টেরটা।
ও নর্মাল ইন্টারেস্ট, নর্মাল গ্র্যাচুইটি,
নর্মাল গ্র্যাচুইটি।
রোপারটা আলাদা।
রোপা লটস।
Ropa
normal gratuity.
Yes.
Not on
the ROPA is the last
one. Last one is the
where is the pension payment order?
No, there is no pension pattern, but sanction order is there as page 11, lordship. This is the bill amount. Page 11, lordship, kindly see.
No, page 12, page 12.
Page 11 is the
No,
bill.
Judge Sahib,
Yes.
Just a minute, it is his petition, just a minute.
Page 11 top gratuity amount written there, leave salary written there. And lordship, page 12 is the sanction order.
This is gratuity and leave salary is also there.
Yes, there. And lordship, page 12 is the order of sanction in respect of gratuity. Page 12.
Now, where from court will find that it was paid on a particular
Yes,
date
lordship,
as you
page
have
14. Page
stated
14.
in
Page,
your in the prayer that is superannuation and that
page 14,
25th August it was paid. Page 14.
Page 14. Check, lordship. Check issued by the company.
Yes, there's delay.
Yes, yes, I'm
entitled to get
6% interest already court will not granted, but your lordships kindly kindly consider the predicament of the company. Millard, I'm really frankly speaking, Millard, company is very financial crunch is there. Your lordships kindly consider nothing, Millard. I am not saying anything. এটা নিয়ে নিন। কোন অর্ডারটা অনিরুদ্ধ বসে?
অরিন্দম মুখার্জি চলে গেছে ফার্স্টে।
হ্যাঁ?
সুরাটটা দিতে যে ফার্স্টটা এটা অনিরুদ্ধ রায়।
কোনটা দিয়েছিস যশোরকে? অরিন্দম মুখার্জি সাহেব একই ছিল।
Where is the order passed in Kajol Pal?
Kajol Pal, I did not got my recent order passed by the Honorable Justice Aniruddha Rai also.
I want, this is the first order, 9th August 2021. Kajol Pal. Where is that order?
Kajol Pal, I did not bought.
Bring it on the next date. That is the parent order as it appears. Issue. File your affidavit service. Affidavit service filed on behalf of the petitioner is taken on record. Matter is heard in presence of the learned advocates representing the petitioner and Durgapur Projects Limited. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on
Tomorrow.
10th November 2025. Monday.
Monday.
Bring that Kajol Pal order because the coordinate bench has relied upon Kajol Pal.
Yes.
And it is also recorded that there was a consensus in between the parties in Kajol Pal. What consensus was arrived at that this court wants to see.
Man.
Yes.
But next 7 to 14, 9 to
Same.
Item 9 to 14.
9 to 14.
This is item number 8.
9 to 14.
9 to 14 same. So rest of the matters no
Same.
order Monday.
Same. Monday.
একসঙ্গে দিয়ে দেবে matter.
Man.
Not affidavit service should on the next day. 9 to
Next day. First matter, affidavit service is filed. Next day, you file affidavit service.
Man. Grateful.
Whatever order will be passed in the first matter, that will govern the other matter.
Others matters. I have objection only on the last matter because of the ROPA 20, because we have already 20 effect, some delays is there. Now they have also will not paid for interest. Already interest was there.
Bring that order, Kajol Pal.
Grateful.
Item number 15.
I have correspondence.
Combine list. List দাও. Combine list দাও. Oh. 14. Yes.
My lord, the petitioner participated in a selection process. Now, my lord, these constitutes of first my lord, the computer-based test which he qualified. Now, my lord, after that, my lord,
Then I participate in the selection process.
Yes.
When?
My lord, it is in 2025. I'm giving the date.
For which post?
My lord, the post is this is an composite post for constable, Central Armed Police Forces, CRPF, SSP, Rifleman, Assam Rifles. So, my lord, these
Post
are,
is constable.
yes,
Constable, Assam Rifles.
Assam Rifles, Central Armed Police
Armed
Forces,
Police Force.
and my lord, Rifleman. My lord, I will show your lordship.
So constable under CAPF.
Yes, absolutely. I'm grateful to your lordship. Now, my lord, after the second round, when he appeared for his height measurement and chest measurement, his height was recorded admittedly as 169 point.
Where is that measurement document?
Page 18. Annexure P3.
What is PST? Not qualified in PST.
Yes, physical standard.
Physical
standard test. So where, my lord, my chest has to be measured.
So why it was rejected? What was the parameters which are required to be
Yes,
followed?
it should be 170. The height-
178
No,
height.
170.
Well,
170.
may I, my lord.
170 height.
Height has to be
It should be
170.
minimum.
But the rules, my lord, suggest, which this coordinate bench has also, my lord, upheld.
Chest normal, chest expanded weight. These are within the parameters.
These are correct. Only the height, now, my lord, when it comes
It
up,
is 170.
Minimum highly required.
now, my lord, when it is 0.5, the rules permits that it will be rounded off to the next. And
No,
the
no, my-
coordinate bench has also upheld that. My lord, I will cite the judgment.
Which judgment? Come copy them.
First, show me the rule where it prescribes that 170 is the parameter.
My lord, I am giving the reference of the rules, my lord. I am not carrying the
Where
rules.
is the rule? Bring the rule.
It's a guideline of May.
Judgment will come later.
Yes, yes.
First, place the
I
fact
have to demonstrate.
based on rule.
Yes, yes, yes.
Where is the rule?
My lord, rule I am not carrying. If your lordship, then my lord, kindly.
Why you have mentioned this matter as urgent matter?
My lord, it was
No, it is not a new motion.
new
Very good.
motion, my lord.
Not this week. Come back on
Yes,
Monday.
yes.
Same, 15 and 16 both.
Very let it be called on one.
Oh, lots.
Bring the rule.
Yes, yes.
Let's
I'm
see
sorry,
the
my
rule
lord.
first.
Absolutely.
Item number 16.
Gives me a rounding of
That is important.
yes.
Without considering the
Yes, yes,
relevant
madam. My
rules,
case, I
how
have to
court can
establish.
derive at a court can derive
I
the
have to
conclusion
establish my
that
case.
it needs to be rounded off to the next higher digit.
Yes, yes. I have to establish my case. I'm
Yes,
grateful.
same issue. Height.
Height.
Where is the document containing measurement? Page 16.
Yes.
This is 169.7.3 difference. Not this week. Next.
Item number 17.
16.
Lordship, I am appearing for the
I'm good.
petitioner in 17.
নাম লিখে দেবো।
এটা 16 হয়ে গেল না? Yes.
Lordship, here, even in this matter, the petitioner before your lordship is a candidate who is participating in the recruitment rules for the constable under CRPF, your lordship. Lordship, the difficulty is that the service is not complete. However, the answering respondent I have served, your lordship.
No, if service is not complete, I will not take up this matter.
Lordship, I only
All the parties have to be served.
I shall serve and come back, your lordship. I only beseech one thing, your lordship. The result for the list of candidates who are to appear for the medical examination is already out, your lordship. So
To be listed on 6th November. If you are not in a position to serve it by 6th November,
I have
why
served,
you
your
have
lordship. The
indicated
track
this?
reports have not come.
Yes.
I have served.
Yes, sir. At the time of call, learned advocate representing the petitioner prays for accommodation to complete service of notice and file affidavit of service. You are representing Union of India?
Yes, my lord.
Union of India is represented by learned advocates. Next paragraph. List the matter under the same heading on
The service completely.
13th November 2025.
Lordship, may I pray for a interim protection, because if the
What's the
medical
urgency?
I'll tell your lordship. The urgency is that the short list of candidates who have qualified for the medical examination is already out. So now, if
When the
date-
medical official examination
has
will
not
commence?
been announced yet, your lordship, but
If it is announced, then mention the matter.
Very
3rd November, 13 November 2025. Next paragraph, learned advocate for the petitioner is directed to complete service of notice upon all the respondents and file affidavit of service on the next time. Next. Yes, call the matters from the monthly list.
Item number 36 for monthly list.
Affidavit of service, my lord. State Bank is the party, my lord. That's what it is. State Bank of
Who is appearing for the statement?
Mr. Subrata Sinha.
So, see, this is a writ petition which was filed on 7th February. So, at the time of filing this writ petition, it was intimated to be moved before a different bench. So, you have to serve it again.
Well, his last occasion, he is there, man. I can intimate him, my lord, fix it on Monday, my lord, I can intimate him and come. He is appearing on that day, my lord, he's there on the last occasion. Fourth.
Not this week, not today. Not today. Come back tomorrow in that.
Well, Monday, my lord, I can.
Why? No, all matters cannot be fixed on Monday. Come back tomorrow. If tomorrow combined list are taken up, this matter will be called.
I am intimating him.
Intimate.
Fine. Deep level.
Not today. এটা কালকের আইডিয়া করে দেখি রাখবে।
Fine.
Item number 43. Yeah.
What's your appeal for the respondents? I'm for the
Of India.
respondents. 1, 2, and 4.
Who are they?
Air India, Air Services, Airport
We are
Services.
the employer, madam. Dispute, Lordship, I have been.
Affidavit of service.
Affidavit of service, Lordship. Yeah.
Respondent number 3 is Airport Authority of India. They have also been implemented as a party, but they have no role to play in this.
They are not?
They have no role to play in this matter, Your Lordship. It's 1, 2, and 4.
So you are representing whom?
I am representing all 4, Your Lordship.
All 4 excepting 3.
As well as 3.
Yes, yes.
My lord, I am challenging the order of termination of my service. My lord, kindly come to page 34. 34. My lord, it was addressed to me on 6 January 2025. This has reference to our letter, white number such and such, whereby you were called upon to show cause as to why the fixed term contract executed between yourself and the company should not be terminated in terms of the relevant clauses of the said contract on account of the serious misconduct committed by you as narrated in our said letter. We have received your reply, wide letter dated 31st December 2024, but the same has not been found satisfactory. The gross misconduct and the serious lapse on your part in performing duties has not only tarnished the image of the company before its valued customers and has also invited severe criticism from our esteemed client, putting our credibility in question. It has therefore been decided to terminate your contractual engagement with immediate effect in terms of clause 12.1d, 12.1e, 12.1f, 12.1g of the contract executed by you with the company. You are required to surrender airport entry permit, company identity card, and other belongings to the company for possession to the office immediately after receipt of this letter. My lord, now kindly come to who am I and how I was inducted in the company. Lordship can find it from paragraph 1. It is stated.
What is the contract, engagement contract?
Yes, my lord.
Contractual engagement letter.
My lord, that engagement letter has not been annexed here.
Why not?
A joining report is annexed.
No, that is important.
That copy.
What are the terms and conditions of your engagement have to be looked
Lordship,
into.
the prevailing practice, this copy was not supplied and it is not supplied by this employer.
Produce that.
I'll give a
You can
copy.
produce it.
Produce
Lordship, allow me to file
That
an
is the
affidavit.
basis of the issue.
Lordship.
Because prima facie,
Lordship.
at first blush, it appears that this is a non-speaking order.
Lordship.
So if contractual engagement permits employer to pass non-speaking orders, then it is different. That's why court is inclined to find out what are the terms and conditions of engagement
Lordship, I shall
on
produce
contract.
that. Lordship. Lordship, allow me to file a short report. We will annex the relevant documents, including the appointment letter. in
Let
that.
them file a report. Let them file. Issue. Affidavit of service filed on behalf of the petitioner is taken on record. In the writ petition, letter of termination dated 6 January 2025 is questioned. and it is submitted that such termination order is non-speaking one. Non-speaking one. Stop. Next paragraph, on perusal of impugned termination letter dated 6 January 2025, it appears petitioner was engaged or petitioner was appointed based on one engagement letter, and such engagement was contractual in nature. Learned advocate representing the petitioner submits that engagement letter was not supplied to him. Stop. Learned advocate representing respondent numbers 1, 2, and 4 has prayed for accommodation to produce engagement letter. Stop. Concerned authority of Airport Services Limited. Airport
Air
Services,
India Airport Services Limited.
Air India Airport Services Limited is directed to file a report. Directed to file a report in the form of affidavit disclosing engagement letter by fortnight from date. So list the matter under the same heading in the monthly combined list of December 2025.
Obliged.
For a date to be fixed. They said dates are fixed in this court, but so many times we are not ready.
Yes.
Item number 44.
For the petitioner yesterday.
You are appearing for the petitioner?
Yes, sir.
Do you want to take another chance so that you can inform? Otherwise, I have to give direction to serve notice again, because this is old service. It was filed in February 2025.
This morning, he told me that he will be present. Now he is not at home.
Well, not this week. Not today. See, if tomorrow matter can be taken up. Inform other side. Not today. এটা কত হলো 44? Yes, Mr. De.
Item number 49.
44.
Very sorry, madam. Just
Item number 44.
ঠিক আছে।
Volunteer force.
Yes, petitioner.
National Volunteer Force.
National Volunteer Force.
Okay. He got the encashment, but the payment was delayed.
It was a substantive engagement.
Yes, according to notification, said he won. Stage 11. Yes, West Bengal on demobilization of 60 years of it.
Just in time.
আরে আমিও নিচে পড়ছিলাম।
So you were engaged as West Bengal National Volunteer in a West Bengal National Volunteer Force. Now, when your service came to an end,
Well, petitioner before your lordship, 2008 to 2020. At page 13, my lord, I made a recommendation. Page 13, I said P2. But
what about court fee? What about court fee? There are 12 petitioners. You have deposited the court fee of one.
oh, court fee, my lord, I shall deposit.
Yes.
Shall deposit after, there are
Have you deposited the deficit court fees?
no other deposit court fees are not being
You have to
paid
deposit it.
after passing of the order. Like this coordinated base that order has been passed, then on deposit of
Order
deposit
নাম
court
কি?
fee, that order will be.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. There are 12 petitioners, but at the time of filing the writ petition, court fee in respect of one petitioner was deposited. Stop. Land deposited. Next paragraph. A land advocate for the petitioners shall be at liberty to deposit deficit court fees by 10 days. By 10 days. Stop. By fortnight. Stop. List the matter under the same heading for further consideration in the monthly combined list of December 2025.
Item number 49.
Lordship, in item number 49, Lordship, Ms. Piali Sengupta is appearing. I led by him for PSC, Lordship. I am praying for not today. She is engaged in court number 36, Lordship.
Yesterday you prayed for time on your behalf, accommodation was prayed for. Not today.
Lordship, grateful, Lordship.
দেখি দাও ফুট ফিটারে ঠিক করে দিন। Issue. Learned advocate representing the petitioners prays for leave to deposit deficit court fees. Stop. On behalf of respondents, on behalf of West Bengal Public Service Commission.
Lordship, PS.
On behalf of West Bengal Public Service Commission, accommodation is prayed for. Next paragraph. Learned advocate for the petitioners is at leave to deposit deficit court fees by fortnight. Stop. List the matter under the same heading for further consideration in the monthly combined list of December 2025.
Grateful, Lordship.
Next.
Item number 53.
My lord, in item number 53, I have
Yes.
some objection, my lord.
What you are, yes. Yes, what you are submitting?
My lord, in item number 53, I have some objection, my lord. In that regard, my lord, kindly turn to page 83 of the writ petition.
Already an order has been passed. Let me.
Lordship, kindly turn to page
Just
8.
a minute.
Lordship,
You are
what-
representing the state.
no, I am not.
You are representing whom?
I have been left out, Lordship. My case is there
Are
on
you
the
party to
basis
this
of,
writ petition?
on the basis of the order.
So then you should.
I am not in the, I am not in.
Take appropriate steps.
Lordship, the similar case is appearing in your Lordships at page 344. Lordship,
Now, affidavit and exception has been have been filed. When why you have not served copy of the affidavit?
Although the state has not yet used that, I am for the respond number 20.
You have for respond number?
20. It is also required to file their
Who are they?
the district judge and the selection committee. Because there are other writ petitions also, they have challenged the entire selection.
They will serve notice upon the learned advocate representing the state respondent, Somnath Noskar and Tapan Mukherjee.
Somnath Noskar, उन्हीं तो senior.
Lordship, kindly turn to page 83.
Please wait. Yes. Serve notice upon them. Not this week. Let it retain its position in the list. Now, your case is if gradation list is changed, then you will be affected.
Lordship, in on the
Answer
basis of
query
the
court.
repetition,
If
on the
gradation list is altered, then you will be affected. Is it your case?
gradation list has been altered on the basis of the order of this honorable court. In my case,
Asking you if gradation list is further altered, you will be affected.
yes,
You are
yes,
the-
yes, yes,
You are the beneficiary to the
yes,
gradation list.
yes.
Yes.
It has been altered on the basis of the order of this honorable court in
Court
my
has-
case.
Court has already observed that the question of making the persons who may be affected by any alteration of the gradation list shall be considered once the affidavits are filed, depending upon the situation. Already court has taken care of your anxiety.
Lordship, kindly turn to page 83 once.
Again, you are not trying to understand the situation.
And Lordship, they are the, Lordship, kindly one moment, Lordship. They are the 2016 LDC direct recruit. 2017 LDC Lordship, 2017 LDC's case is at your Lordship list as
In terms of the order
item
dated
344.
March 25.
My lord, kindly give me liberty to.
Filed on behalf of respondent, number 2, and same is taken on record.
2 and 3.
2 and 3.
There are so many petitioners.
What about the court fees?
Yes, my lord. The visit court fees have been paid.
Have you deposited?
My lord, that is
That has
reflected in
been
the order.
recorded in the last order. So for line starts with.
However, no one is representing the state respondent. State's response is required. No one is representing the state respondents. Next paragraph. Learned advocate for the petitioners is directed to serve notice upon the learned advocate representing the state respondents, enclosing copy of this order by November 10th, 2025.
Kindly give me liberty to file an exception of this report, my lord.
Stop. Hearing of this matter stands adjourned till 17th November 2025. Stop. Next paragraph. Petitioner shall be at liberty to file exception to the report filed on behalf of respondent numbers
2 and 3.
2 and 3. In the meantime.
Lordship, what about my case, Lordship? They have not been made party to me, Lordship.
Whatever is required to be expressed, I have stated already. If you cannot understand, I am unable to make you understand. Yes, next.
Item number 57.
Lordship, I am appealing for the petition. Lordship, in this petition, I have challenged the order of the managing director of the Calcutta Street Transport Corporation refusing my prayer for the disbursement of pension in the Calcutta Street Transport Corporation DCRB scheme. Lordship, the issue is that as per Deputation 6, the DCRB scheme is optional before getting my pension. Now what happens, Your Lordship? The regulation 64 of the said scheme says that as
When you have retired?
I used to retire in January 26 year. I have no. So Your Lordship, I pledge before Your Lordship to set aside the.
So you are working under where? Calcutta State Transport
Corporation. Now regulation 64 of the regulation says the very moment an employee goes for pension, he has to be covered under GPA. Lordship, the petitioner was appointed in 1990. At that point of time, there is no scheme because the scheme is of 1990 with retrospect effect from 1/4/1984. Your Lordship, I exercised my option, Your Lordship. I exercised my option. They did not transfer me from CPF to GPA. Lordship, I preferred a petition before this honorable court. The honorable court, my lord, will see annexure P1.
Annexure?
P1, that's only 2 annexures, only P1 annexure at page number 23. The order passed by my lord Justice Mukherjee. The second paragraph. In the aforesaid facts and circumstances, The managing director, Calcutta State Transport Corporation, being the respondent number 5, shall look into the option given by the petitioner, which appears at page number 18 of the petition. I have and enclose that option and pass a recent order stating as to whether the petition shall be governed under the GPF scheme or the CPF scheme. In the event the petitioner is found to be governed by the GPF scheme, the respondent number 5 shall direct the department to calculate the amount, if any, which has been deducted in excess from the petitioner, while the petitioner has been treated to be under CPF scheme and not under the GPF scheme, and give necessary adjustments. In the event any loan amount is outstanding, then the excess amount, if any, shall be adjusted against the outstanding loan amount. In case the petition has to refund any money for being treated under the GPF scheme, the petitioner shall be informed about the same and a time sheet to be provided for refund of such money. The entire exercise has to be completed within 3 months from the date of communication of this order. If the petition is found to be covered under the GPF scheme, then the petitioner shall be treated to be an employee governed under the GPF scheme. Then he should be treated so far from the retrospective date as per option. The detailed calculation of the amount which is required to be covered or adjusted or which is to be refunded by the petitioner shall be provided to the petitioner by 31st of March 2025, or so that necessary steps in terms of this order can be taken immediately on furnishing the same. This order is being passed keeping in mind the ratio laid down in Calcutta State Transport Corporation others versus Washington 2023 SCC online SC 594. Now, Your Lordship, the apex court in Washington of this case had observed that as the petitioner.
Now, what exercise has been carried out by the authorities in terms of this order?
For pension, Your Lordship, and as per the government memorandum, it
No, no. In terms of this order dated 2nd January 2025, what was the what were the steps taken by the authority?
Lordship, they have asked because they have seen, they have taken that you have to see the propriety of the option whether it has been exercised or not. In the managing director passed an order stating that yes, I exercised my option in 1991, but they have taken the plea that subsequently I withdraw. But
Where is that order?
Lordship, the next P2, Alship P2, page number 26, the order passed, which is impugned here in Your Lordship. Your Lordship, kindly see Your Lordship. The petitioner joined the corporation on 6/8/1990. At that point of time, the scheme was not there.
That's
Paragraph 3rd, he opted for pension. So they have to implement my lord's order, Mr. Mukherjee's order.
We have already, by submitting affidavit, withdrawn from,
There is no.
made a statement that you did not want to get the benefit of general provident fund and pension.
Political court decided we cannot once go for pension, you cannot go by that. This is the.
What about it is waiver by conduct.
Absolutely not, Your Lordship. This is
You
the
have
moment
you
of-
have yourself tendered. What Honorable High Court has said.
Honorable High Court said that once option has been exercised, you cannot re-opt or you cannot come out from that option.
Did you disclose it in your writ petition that you filed affidavit? Show me.
Lordship, that I have filed one.
Yes, in the previous writ petition.
In the previous.
Yes. In the writ petition of being WPA 27573 of 2024, did you disclose that you affirmed an affidavit in order to withdraw yourself from contributory from pension scheme? Where you have disclosed in your first writ petition? Show me.
Lordship, I have this, but the repetition is not with me right now, but the thing is that Your Lordship, the Honorable.
Show me that you have disclosed it first. Answer what Honorable Court has said that will come later. First, disclose that you have disclosed this fact that by submitting or tendering affidavit, you have withdrawn yourself from pension scheme.
Lordship, may I submit one thing, Your Lordship? I preferred this repetition in 2020.
I want that you have disclosed this fact before the coordinate bench.
Because on 8th of May 2023, Your Lordship, the Honorable Apex Court held that once you have exercised your option, so you are covered under the GPF. That I have annexed in my repetition in Oshin Chakraborty's case. Marat, I can show that. In 2024, when I preferred this petition, I said I opted for pension in 1991. It is the duty of the employer to convert me from CPF to GPF.
What was the order at page 23, second paragraph? In the aforesaid facts and circumstances.
Page number 23, Your Lordship.
Yes, of the coordinate bench.
Lordship, page number 23, paragraph number, second paragraph, Your Lordship. Lordship. That they have to see whether the option is correct or not. They say
And
yes.
pass a reasoned order stating as to whether petitioner shall be governed under GPF scheme or CPF scheme.
Lordship, in the view of that option form that I opted for pension on 8th of May 2023, on 8th of May 2023, it was filed by the Honorable Apex Court that once you have opted for pension. Lordship, the order has already been, my lord, may I? The Honorable Apex Court said that option is full and final. So I can show before this Honorable Court.
File your affidavit.
Lordship, let them file their affidavit. So CSTC has to file. The state has nothing to do.
Affidavit of service.
Lordship, it was given long back, Your Lordship. It was heard by
filed?
Justice Mukherjee, Your Lordship. Now the managing director has to file.
In the writ petition, order of the managing director, Calcutta State Transport Corporation, which was communicated via letter, via memo dated 7th March 2025, is questioned. Next paragraph, on perusal of said order of the managing director, which is at pages 26 and 27 of the writ petition, it appears, taking note of the affidavit affirmed by the petitioner, prayer of the petitioner to be governed under pension scheme was turned down. Stop. State respond. You are for the
state.
State. Who is for Calcutta State Transport Corporation?
My lord, when this matter was heard, initially Mr. Sen was appearing, but now my lord,
HON'BLE Sen.
senior friend is appearing.
Mr.
for
HON'BLE
case
Sen
six.
was appearing actually.
Acha.
For the
Considering the issue involved in on perusal of the order, impugned order issued by the managing director, Calcutta State Transport Corporation, court finds legality and validity of the same needs to be decided on exchange of affidavits. Stop. Let affidavit in opposition to this writ petition be filed by 4 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Stop. Next paragraph, petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits. Next paragraph, Knight advocate for the petitioner is directed to communicate this order to the non-appearing respondents by 7 days from date and file further affidavit of service on the next day. Next.
Item number 58.
Lord, I appear for the Calcutta State Transport Corporation.
Petitioners are not retired employees of the Calcutta State Transport Corporation. So they were entitled to, my lord, 300 days of earned leave encashment. Instead of that, my lord, they have been paid.
Yes, yes.
So the petitioners are the retired employees of the Calcutta State Transport Corporation. So they were entitled to leave encashment for up to the period of 300 days. Instead of that, my lord, they have been paid leave encashment for 180 days. But they have made representation to the CSTC authorities, my lord, for consideration. But the representations have not been considered. But similar writ petitions, my lord, have already been disposed of.
What is the prayer made in this writ petition?
Payment of 150 days of
Page 13.
Yeah. There are mandamus commanding the respondents to pay all the petitioners their due encashment of 150 days out of total maximum of 300 of unutilized accumulated earned leave with interest at the rate of 8% per annum. Thereupon, from the date succeeding to the date of their return. The actual dates of the see the main plan.
এই তো কি নামটা এনেছো সই করতে আবার কবে কর পরিমল দেব এটা কবে করো 7th এপ্রিল এটা কবে করো হ্যাঁ
So the entire amount of leave encashment has not been released.
Oh, yes.
এটা চেপে যাও
I am entitled to 300 days up to the limit of 300
So
days.
it was paid up to the extent of 120 days.
180 days have been paid.
120 days
left.
Yes. We made representations to the authorities that have not been considered. More similar petition will have been
Court fee
court will I have paid subsequently. Yes.
for all the petitioners.
Yes.
Why 120 days
I
leave salary was not paid?
But I pay for the Calcutta State Transport Corporation.
Yes, yes.
My lord,
Leave encashment for 120 days according to the petitioner. they are
according to
entitled
him,
leave.
that 300 days is the ceiling limit.
Yes.
So that is the maximum. So, my lord, I have not received instructions, but maximum is not, my lord,
So if
person.
it is maximum 300 days.
He'll be
you-
paying, he'll be
if you
paying.
are paid for 180 days. Why petitioners will not get the benefit of 120?
Well, I can either file a report or to that extent, or my learned, subject to your lordship's pleasure, what are the honor? My learned friend had appeared in the similar matter with the self-same prayer. My lord, I must have filed several repetitions. My lord, this was the order disposing of, he was agreeable to be considered. But if your lordship wants,
Where is the representation?
my lord, have a look at kindly. There are several representations.
52 to 57.
Your lordship, can you take the last representation, which is at page?
The joint representation, no.
Single.
Is there any joint representation
No more.
by all the petitioners? No. Now, who will consider it? Managing director.
And petition has already been passed, my lord, or similar.
So yes, your prayer is twofold. First is 120 days leave encashment benefits,
Yes.
which has not yet been paid, and interest thereon. Very well, Mr. Bihani, I will grant leave to the petitioners to make a composite representation to the managing director
Yes.
within certain time, and that will be considered in accordance with law.
Yes.
Issue.
My lord, only one thing,
Yes.
the reason why I troubled your lordship by handing this over this copy.
Yes.
My lord, if your
The order of the coordinate bench.
yes, my lord, I'll not trouble your lordship with it because lordship will pass your lordship's order.
Yes.
Kindly takes, my lord, paragraph 10. 10 today. Yes, at page 3. My lord, if your lordship considers incorporating this because the financial burden of the state component also comes in.
After consideration by the government authority.
That's correct. If your lordship considers this to be the state also, finance also to be this part to be taken into account.
For payment by the system.
But I'll explain to your lordship why I'm making this submission and why I admit.
Financial constraints of.
Not only that, my lord, number one, number two, sometimes the contempts are filed wherein, my lord, the burden is shifted. Who is to do that? To streamline that, my lord, if your lordship considers this.
Why court will enter into this issue? It is internal arrangement so far. State Calcutta State Transport.
That is why, my lord, the
Corporation
honorable court has not entered into it. Kindly sees and or. It is and or.
issue.
Lordship.
Matter is heard in presence of petitioners are the retired employees.
Yes.
Petitioners are the retired employees of Calcutta State Transport Corporation who have approached this court with the present writ petition voicing grievance that though they are entitled to get leave encashment benefit for maximum period of 300 days, comma, they were paid leave encashment benefit for 180 days.
180 days.
180 days at the time of their superannuation. Top. Petitioners apostrophe, plural apostrophe, petitioners common grievances though they are entitled to receive 300 days leave in though they are entitled to receive leave encashment benefit for a period of 300 days, denying their such right, leave encashment benefit for a period of 120 days was not paid. Prayer is also made. Now, stop. It is also contended on behalf of the petitioners that petitioners that they are also entitled to receive interest on unpaid leave encashment benefits due to delayed payment. Next paragraph, West Bengal State Transport Corporation and state respondents are represented by
Calcutta State.
Calcutta State Transport Corporation and state respondents are represented by learned advocates who have submitted. Calcutta State Transport Corporation is represented by Mr. Bihani, learned senior advocate, who submits as per norms on superannuation. Employees of Calcutta State Transport Corporation may be paid leave encashment benefits for a maximum period of 300 days. But ipso facto, same does not confer right upon the retired employees to claim such benefits for the said maximum period of 300 days. In the present case, benefit towards leave encashment have already been paid to the petitioners for a period of 180 days. Therefore, nothing is left to be paid. Stop. Next paragraph. State respondents are represented by learned advocate who reiterates the submission made on behalf of Calcutta State Transport Corporation. Stop. Next paragraph. Having considered the submissions made on behalf of the parties, it is found that retired employees of State Transport Corporation, Calcutta State Transport Corporation, can be provided benefit of leave encashment, leave encashment for the maximum period of 300 days. But in the present case, such benefit is paid for a period of 180 days. Stop. Question remains whether petitioners are entitled to get leave encashment benefits for 120 days more or not.
There is no dispute, but our managing director has already passed an order in favor of an employee.
Next paragraph. Having considered the issue involved in this writ petition, court finds no purpose would be subserved in keeping this writ petition pending. Stop. Next paragraph. Leave is granted to the petitioners to make a joint representation within a period of fortnight from date to the managing director, Calcutta State Transport Corporation, claiming leave encashment benefits for 120 days for 120 days. Stop. If such representation is made within the aforesaid time, managing director, Calcutta State Transport Corporation, being respondent number 6, shall decide the same within 8 weeks thereafter, within 8 weeks thereafter, on granting opportunity of hearing to the petitioners or opportunity of hearing to one representative of the petitioners. stop. Petitioner shall be at petitioner shall be at leave to produce relevant documents in support of their case before the respondent number 6. Next paragraph, respondent number 6 shall pass a reasoned order and same shall be communicated to the petitioners by 10 days thereafter. Next paragraph. With the aforesaid directions, writ petition stands disposed of. Next.
Item number 59. 59, Lordship, I am appearing for the private respondent number 4, your Lordship.
In another matter, Mr. Tapan Kumar Mukherjee and Somnath Noskar. You are Mr. Noskar.
Yes, sir.
Both are appearing, but at the time of call, both are appearing for the state respondents. But at the time of call, state respondents remained unrepresented.
What is your Lordship?
Today's list.
I'm sorry.
Which item? You are there? 53. And state was directed to file a report. Make a note, come back. Matter has been, when matter will come up, Mr. Mukherjee?
53, 17 November. 17 November.
17.
53 আর affidavit দিতে বলেছিল কিন্তু reporting.
I'm sorry.
Appear on the next date.
Yes, yes, master.
Yes, who is for the petition?
This is my affidavit in service, my lord. The matter, the short point of law is involved in this matter, my lord. This is a checkered history, but the short point involved the whether the respondent authority have had jurisdictions in the matter of adjudication of the marriage status of the petitioner by under the use of a inquiry based on an inquiry procedure, ignoring the judgment of the Honorable High Court and the Civil Court. This is the short point of law involved in this matter, my lord. Without giving trouble much more, I want to produce before your lordship the compilation of the judgment passed by the Honorable High Court and Civil Court and the judgment relied by me, my lord, and the written notes of arguments.
Who is representing respondent number 3 and 4?
He not served, my lord. He has not service not affected.
Why?
That's because he refused to take. And four has been appeared, and second and first appeared.
Second I'm appearing. First I'm not appearing.
State,
my lord.
State, who is appearing?
State, I do not. I have served.
4 is a private respondent. I thought you are appearing for the state.
No, your Lordship. Private respondent.
Private respondent.
What about the service upon the state?
State, I have served, but none appeared, my lord.
Then you have to serve it again. Affidavit of service filed because this is old service of March 2025.
Yes.
Affidavit of service filed on behalf of the petitioner is taken
But
on
the
record.
appearance of the
Paragraph. Learned advocate representing the petitioner is directed to serve notice upon non-appearing respondent or the learned advocate representing the said respondent, enclosing copy of this order by 7 days from date and file further affidavit of service on the next date. Non-appearing respondents or the learned advocates representing those respondents by 7 days from or by 10 days from date and file affidavit of service on the next date. Next paragraph. List the matter under the same heading for further consideration in the monthly combined.
My lord, 2 and 4 appeared. My lord, kindly record it. My lord, 2 and 4 appeared.
It's not required.
Oh,
non-appearing respondents.
Yeah, not appeared. Much.
So you need to make an attempt to effect service. You need to make an attempt to effect service afresh upon respondent number 3. So list the matter.
1 week.
Same heading
Within
for
1 week, my lord. Within 1 week, I will serve.
December 2025. Next.
Item number 60.
My lord, appear for the respondent Digha Shankarpur Development Authority.
Petitioner, my lord. My lord, petitioner was been given as a contractual electrician by the Digha Shankarpur Development, but that is the respondent number 1. In the meantime, there was a matter was filed by other
employees of the Digha Shankarpur. During the pendency of that matter, the petitioner has been transferred to DM office, which is very far away from petitioner's residential home. So petitioner is paying just to join to the original posting. And I have made.
When the transfer order was issued,
my lord, I will.
you are appearing for Digha Shankarpur.
I'm for the
State.
state.
টাইটেল নাম্বারটা লিখে দিচ্ছি 62
My lord, order.
এটা কি কোথায় গেল?
In 13 September 2024.
Where is the order of transfer?
My lord, that is not there with me, my lord.
It will not be there. My specific instruction is, my lord, it is in electronic form.
Yes.
Instruction is that, my lord, in April 2022, he is left out of his own volition. It was not, there was no transfer order. But Lordship will kindly visualize, admittedly is contractual. So he cannot be, there cannot be subject to correction, but also a transfer order. So he left of his own volition in 2022 April. Now in 2024, my lord, all these operation and maintenance work where these contract laborers are working have been handed over to government PWD. The entire thing has been completed and handed over. Now he, in retrospect, he wants that by in this way of a representation to be considered order, he can again get in so that. The first round was equal pay for equal work.
Affidavit of service previously you have filed.
No, my lord, this is my affidavit of service.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Petitioner prays for a direction which would permit him to continue his service under Digha Shankarpur Development Authority on contractual basis.
Master role employee. Master role employee. Master role employee, not contractual.
Oh. As master role employee. Where he was previously working. At a place where he was previously working. Stop. Next paragraph. Such prayer is opposed by the learned by Mr. Bihani, learned senior advocate representing Digha Shankarpur Development Authority, and it is submitted that when petitioner left out April 2022.
Not April 2022.
And it is submitted that petitioner left the job in April 2022. Stop. Next slide. Concerned authority of Digha Shankarpur Development, concerned authority of Digha Shankarpur Development Authority is directed to file a report in the form of affidavit disclosing the relevant facts by fortnight from date. Stop. List the matter under the same heading for further consideration in the monthly combined list of December 2024.
May I pray for one more extra week?
Well, 3 weeks. Fortnight or 3 weeks.
If I want to file any exception to that one,
Let me see what comes.
Lordship.
Your prayer is also very omnibus prayer. I have seen. Perhaps no exception is needed.
Item number 61.
My lord, I appear for the opposite party's
This is
respondent.
petitions for praying for a family pension of an unmarried daughter. Lordship, the father of the petitioner was a Lordship, the employee of
for the state.
India.
No, my lord, I am for the United India Insurance Company. State is
Now-
not a party here, my lord.
Lordship, the father of the petitioner was an employee of United India Insurance
All
Company
respondents are
Limited.
represented.
I am
They are
representing
representing
all
the
the respondents.
Father of the petitioner?
Was an employee of United India Insurance Company Limited. Now, Lordship, the father.
When father died?
The father died in
After
12th of,
retirement or in harness?
12th of September
Just a
2004.
minute. When father retired?
Lordship, the father retired on 31st August 1990.
No, but retired in 1990.
Yes, that is what I am asking. Why
Yes,
you are
so
saying no?
It's a
Wait,
very expired.
allow him to make submission. Then your turn will come. Father retired on 31st August 1990. Then father was in receipt of pension.
Now, Lordship, the
Then when
ex-
father died?
on 12th September 2004.
Mother was receiving family pension.
Yes. Now, subsequently, mother
died on?
family pension. Now, Lordship, subsequently, mother expired on 20th November 2024.
20 November 2024.
24.
Now the petitioner, being the unmarried daughter, is claiming family pension.
Yes.
Is there any provision for sanctioning family pension?
Yes. Now, Lordship, in terms of the previous, this rules has been enacted in the 19 central government civils, because before that, Lordship, I'm just praying for a Lordship's attention to the memorandum that these employees will be guided for the purpose of calculation of pension, guided by the Central Civil Services Pension Rules 1972, which has been repealed now 2021. Kindly come page 37.
Stand here now.
Yes, page
Scheme,
37.
This is a scheme, General Insurance Employee Scheme, Pension Scheme of 1995. Now kindly come 54B.
Yes.
Notwithstanding anything contained in this scheme in respect of the employee covered by the proviso to clause K of paragraph 2, who are in service on or after 1st January 1996, the pensionary benefits shall be calculated in accordance with the provisions contained in the Central Civil Services Pension Rules 1972 and the Central Civil Services Commutation of Pension Rules 1981 as applicable to central government servants in accordance with the instruction issued by the central government thereunder from time to time. So, Lordship, subsequently the 1972 rules has been repealed. Now is 21 rules.
But where is the provision here for grant of family pension?
Lordship, the 1970 rules permitted the unmarried daughter to get the family pension.
But what is the part of the first paragraph under clause 54B?
Yes, notwithstanding anything, in respect to the employee covered under proviso clause K, Lordship, this is absolutely.
Or paragraph 2, who was in service on or after 1st of January 1996. Petitioner retired in 1990.
No,
not petitioner, father of the petitioner retired in 1990.
Not.
Yes. What
Yes,
more?
in 1990.
So, and it says who was in service on or after 1st January 1996. The pensionary benefit shall be calculated in accordance with the provisions contained in Central Civil Service Pension Rules 1972 and the Central Civil Service Commutation of Pension Rules 1981 as applicable to the central government servants and in accordance with the instructions issued by the central government thereunder from time to time. And it is restricted to pension only. Even if provisions are there in 1972 rules or amended rules of 1921, how this is applicable in your case?
Now applicable because no, my only intention is that this pension, determination of pension, entitlement of pension will be covered.
Your contention, I understand, in 2021 amended rules, there is a provision.
There is a provision that.
But straightway it will not apply in view of these conditions attached herein under 54B.
Now, because this is.
To whom it is applicable? Those employees who were on or were on service
Kindly
or
cover provision.
on service on 1st of January 1996 or thereafter. And it is restricted to pension only.
Now, kindly come the proviso.
Yes, what is your instruction?
My lord,
Now, lots of
first-
only one thing. Lots of the pension
That's-
process has been started. That's why I'm.
That's why I am also
Now, pension
asking her,
process
what is
has
your
been
first of
started.
all, there is
Wait,
no
wait,
scope
wait.
of family pension in this matter. There is no scope of family pension. There is no such rule, and the rule which they are providing, they have not annexed anything that family pension or the daughter will be getting any pension. That is not annexed, and that is not stated anywhere in the rules. And secondly, my lord, the petitioner.
2021 rules straightway ipso facto cannot apply unless and until conditions, suitable conditions or provisions are there under clause 54B.
And also the petitioners are, my lord, petitioner, my lord, petitioners.
No, process has been started. So what is he saying? I don't know.
What process? I have no instruction. What is
Started with the
protest?
letter to my client. That's why I'm Lordship the harping that Lordship the.
As per our investigation, my lord, the petitioner is working. She is able-bodied. She is earning. She is earning, and she is more than 25 years of age. She is 56 now, my lord. She has crossed 25 years of age. She is unmarried, but she is working. She is working. She is working, and that to them. There is no provision of any family pension in this rule.
Process has been started. I have submitted document, hearing concluded, but no Lordship decision has been given.
Then process has been started. How can you say that?
Issue is not ended.
Hearing has been concluded. Hearing has concluded. Process is not. You cannot say that process has started because we don't have the instruction that any process of pension has been started. আমার কাছে তো ইনস্ট্রাকশন নেই না আমাদের ইনস্ট্রাকশন না আমার কাছে যে ইনস্ট্রাকশন আছে সেটাই বলছি আমি আমাদের কাছে ইনস্ট্রাকশন নেই যে প্রসেস স্টার্ট হয়ে গেছে এসব কোনো ইনস্ট্রাকশন নেই আমার page paragraph page 8
If there is no provision for sanctioning family pension to unmarried daughter, then why this letter was issued?
well, I don't know what letter because I don't have this letter.
Why this letter was issued? Simply by one line letter, it could have been negated.
এই অ্যাসিউরেন্সটা এরা সিসিএস রুলস দ্বারা কোন হচ্ছে কোন জায়গাটা After January 1990.
Sir,
There are two aspects. See,
a report has been
one
filed
is-
to this.
One is that under the pension scheme, there is no provision for sanctioning family pension to unmarried daughter.
Yes.
This is one aspect. If that be so, in that event, by one line later, it could have been declined.
Yes.
Prayer could have been declined. And the another option is this, that yes, pension, family pension can be granted or allowed to an unmarried daughter in an appropriate case.
Yes.
If conditions are fulfilled.
This is a
Which
case,
is the
my lord.
present,
Yes,
which is
my
the
lord.
position I am trying to elicit from
Yes,
it.
my lord. On this letter, a report has been given to us by the same Mr. D.
Is it a
Bose.
case of no provision to sanction family pension to an to unmarried daughter, or it is a case that there is a provision?
There is no
to
provision.
sanction on family pension to an unmarried daughter, provided certain conditions are fulfilled.
My lord, the
What is
second
the
case,
situation?
the situation here is, my lord, since the mother was getting the pension, mother
has died.
Mother has
Question
died.
of mother.
The daughters, there are 4 daughters, my lord. They are
want to know
their
that
other
what is
family.
the pension scheme?
Other pension scheme is that they don't have any
That case,
provision.
unmarried daughters in a certain
Case,
situation,
appropriate case may get
an
on
appropriate
humanitarian ground.
daughters are eligible to get pension
On
or not?
humanitarian ground they can get if they are not earning. So for that reason they required certain documents that they are not earning, they are not in well to do. Those documents were required. So an investigator was appointed. The investigation report has been handed over to us, and in that investigation report it has been found that she is well earning. She is a private tutor. They have their own house on 4 cutters
Show
of
me
land.
the provision
My lord.
under which an unmarried daughter in an appropriate case is eligible to get family pension.
Well, as per my instruction, there is no scope in there in the United Kingdom. But
That
I
is
wish
not the query of the court.
I'll take
Whether
instruction.
application of such provision in the present case is properly made or not.
Yes.
In order to assess this or in order to examine this, provisions are required to be placed before this court.
Yes.
If you say no, there is no such provision, we don't give family pension to any unmarried daughter, matter ends. If provisions are there that in an appropriate case family pension can be paid, then where is such provision?
I shall.
You have to place it before
I'll
this
place it
court
before me.
in order to apprise this court that yes, there is a provision, but in certain conditions, these provisions, this family pension can be allowed to the petitioner. But here in this instant case, these provisions are not attracted.
Well, I shall take the instruction.
So far the CCS pensions rules is concerned. Now,
Yes, sure.
the amendment is there.
The affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioner's father was an employee of United India Insurance Company Limited, who retired on superannuation on 31st August 1990. After superannuation of the petitioner, father of the petitioner was in receipt of pension. Stop. Father died on 12th September 2004. Stop. Thereafter, mother of the petitioner was receiving family pension, who died on 20 November 2024. Stop. Petitioner is unmarried daughter, comma, according to the learned advocate, petitioner is unmarried daughter, comma, it is submitted on behalf of the petition, it is submitted that petitioner is entitled to receive family pension. Stop. Give me that document. In support of such contention, one letter dated 4th June 2025, issued by Deputy Manager, Pension Department, United India Insurance Company Limited, addressed to অ্যাড্রেসটা কেটে দাও। কি বললাম? ইন সাপোর্ট অফ is placed before this court and same is taken on record. Copy of the letter করে দাও। Copy of the letter dated so and so is placed before this court, same is taken on record. Stop. According to the stop. It is submitted based on such letter dated 4 June 2025 that steps have already been taken by the concerned authority of United India Insurance Company Limited for processing family pension case of the petition. Next paragraph. Learned advocate representing the insurance company has submitted that petitioner is not eligible to get family pension, but it is not demonstrated as to why petitioner is not eligible. Stop. Let a report be filed on the issue involved in this writ petition by fortnight from date. Stop. List the matter under the same heading for further consideration in the monthly combined list of December 2025.
No, I shall file also the report which has been given by the same authority to whom this
It is up
was
to you,
issued.
but you have to demonstrate that why petitioner is ineligible to get family pension.
It be obliged.
Also, may I get the letter?
No, it is taken on record. You can get a printout or at a Xerox করে ওকে দিয়ে দিতে হবে। Yes, next.
Item number 62.
It be obliged.
क्यों नहीं? Yeah, but I'm for the statement.
At the time of call, no one appears for the petitioner. And at the time of call, no one appears for the petitioner and no accommodation is paid for. Next paragraph, however, state respondents are represented by learned advocates. Next paragraph, list the matter under the same heading for further consideration on or list the matter under the heading motion quote unquote for further consideration on 18th November 2025. Next paragraph. It is made clear if on the urgent date, it is made clear if on the next date petitioner goes unrepresented, consequential order shall be passed. Next.
Item number 63.
Yes.
Matter is a long history of this matter, but in nutshell, I appointed as constable.
Long history.
In border security.
All parties are present.
But I am representing the rest.
Only the border security force as constable in the year of 2013, specifically April of 2013. Thereafter, on 2015, August 2015, a medical board detected that I am a colorblind and my service was terminated.
When you were appointed?
8 April 2013.
Exact date, my lord. Yes, when it was detection that petitioner is colorblind.
That was on 10th August 2015.
10th August 2015.
2015.
Yes.
Terminated. I assessed that order before this honorable court. This honorable court directed the authority to reinstate me in a position where the public safety is not
where
the public safety is not very much essential with all consequential benefits. That order challenged before the honorable division bench. Honorable division bench confirmed the order of the honorable single bench.
Thereafter, the authority reinstated me, did not reinstate me. So I moved an application for contempt. During pendency of the contempt, I reinstated. But the fact is this, my lord, the period, intervening period from the date of my dismissal to reinstatement, that
When
period
you were
was-
reinstated?
I reinstated on 29/12,
22.
29th December 2022.
2020?
2022, page 133, my lord.
Yes.
But the intervening period, that is from the date of termination to reinstatement, that was treated extraordinary leave. Although, as per the direction of the Honorable Court, I am entitled to get the all benefits. But at first, I am
Extraordinary leave, it was treated. What you are praying for in this writ petition?
I am praying for that that period be treated as a unlived, because of the reason, my lord. Unlived. Because of the reason, my lord. If your lordship permits me, then I can rely the provision itself, which is relied by the authority.
No, first order of the coordinate
Order
bench
of
is to
the
be
order of the coordinate bench. My lord, that is on page 76. Start from 76. And this is a long judgment. My lord, kindly come to page 76. The last but one paragraph, that the respondent number 3 is directed to revisit the claim of the petitioner in the light of the beneficial provisions for utilization of his service in job.
Just a minute.
But the sole issue which is involved specifically is whether he is entitled to the financial benefits for those 2598 days.
Yes.
Whether he is entitled to
coming.
financial benefits for those 2598 days when he didn't serve the BSF, and that was
I'm coming
treated
on
as
that.
extraordinary leave.
Extraordinary.
That is the issue.
But if the order of termination was set aside by the court, it was
set
whose
aside.
fault? For whom he has lost this period?
Not the medical inquiry which was set up, it came up that he was suffering from color blindness.
It was a case of termination.
Termination.
Yes. If it is a case of termination and the termination order goes. Now, in the
Reinstated.
previous writ petition, did you pray for reinstatement along with back wages?
But
show me the prayer in the previous writ petition that is generally prayed for.
My lord, that is not here, my lord. But I can satisfy your lordship from
Then-
the order itself.
Then there is a difficulty. Show me
There is
the previous writ petition. What was the prayer couched in that writ
My lord,
petition?
kindly allow me
What is falling from your lordship is specifically that's my instruction, written
My
instruction.
lord, kindly allow me for 1 minute. My lord, kindly.
And in the order of the coordinate base, there was no direction for back wages.
No, the petitioner shall be entitled to continuity in service.
That we have
And
provided.
regulation
Then
of
you
his
are hit
benefit
by
and
constructive res judicata.
My lord, now kindly allow me to place the provision.
No, that provision will come later.
My lord.
First, show me the prayer in the first writ petition.
That is not with me.
Bring
at
that
this
writ
moment,
petition.
my lord. But
Bring that writ petition.
I shall come.
Yes. Come and satisfy this court, then court will further consider the relevant provisions. But if it is found that in that writ petition you prayed for back wages and that was turned down, subsequently you have no scope.
Statute is very clear. Kindly allow me.
Maybe,
Kindly allow me
but
to
once the issue was decided by this court,
I shall try
you are
to
hit
satisfy
by
your lordship.
constructive res judicata.
I shall try to.
Because it was the issue in previous writ petition.
I shall try.
But your attempt must be based on the prayer made in the first writ petition. Where is the prayer?
But if my lord, if I assume
When the
my lord, kindly
contempt
allow me.
application came up before
Do
the
you have a copy of the previous writ petition?
No, my lord.
Kindly allow me, my lord, to place the provision itself where the statutory provision is very much
was working.
Very much clear, my lord. My lord, fundamental rule is very much clear in this point.
Border security force.
Border
security.
Petitioner was working in border security force and was terminated. What is the date of termination?
Date of termination was, my lord.
20. It is instated.
Date of termination was. That was with effect from 10th August 2015. It was given retrospective effect. The memo was issued on 19 May 2016.
ठीक है पेज 10,000
Now, at the time of fixing your pay
Yes, my lord.
on reinstatement, whether your past service was taken into consideration.
Past service was taken into consideration.
Rightly done. Page 76, last paragraph. Petitioner shall be entitled to continuity in service and regularization of his benefits in accordance with law.
Yes. My lord, kindly,
has already been
kindly, my lord, kindly sees the order.
So this is the answer of the coordinate bench.
My lord. My lord, kindly.
And you were granted continuity in service.
Now the
So coordinate bench thought it fit not to direct the authorities to
Certainly, my lord.
direction for release of back salaries.
Back salary or for the period when I didn't serve. But the statute is very clear.
and that was
My
not
lord,
interfered by the division bench
kindly allow
in
me,
contempt.
my lord, kindly allow me to place.
I have allowed you a lot in this matter. No further
Allowed to?
permission is required.
My lord, permission is required on
Yes.
this on the score. My lord, kindly come page 132. Here the authority, it is passed by the
What is the order
authority.
of the division bench?
My lord, it's in page 92 is the ordering portion. It starts from 92.
104 is the final part, operative part.
Now, in terms of the order of the coordinate judgment of the coordinate bench dated 5th July 2017, which merged with the judgment of the honorable division bench dated 30th June 2022, issue was revisited. And where is the order?
That order 128. The operative part page 131 and 130.
One
128.
Issue.
My lord, now,
my lord, after page
my lord,
130, the order
Here this court. Here the order to be passed. In this matter. Today is not, I'm not passing final order.
Fine.
Petitioner কি বলছিলেন? And was terminated by the order dated 10th August 2015. So, said order of termination was questioned in the writ petition being WP A 14868 of 2016. Stop. On allowing writ petition a coordinate bench delivered judgment on 5th July 2017. Directing the concerned authority of border security force for short BSF BSF to revisit the claim of the petitioner. So, judgment of the coordinate bench dated 5th July 2017 was questioned by preferring intra-court appeal, being FMA 1798 of 2018. But the order of the but the judgment of the coordinate bench dated 5th July 2017 was not interfered with. Stop. Concerned authority of BSF with a order passed in December. What is the date of order?
This 29th December 2022. He was reinstated.
Video order dated it was signed on 15 December 2022, page 132.
Date of reinstatement, my lord, 28th December 2022. Page 133.
Video order passed in December 2022. Reinstated the petitioner.
Order তাই বলা service with effect from 20.
Stop. Next paragraph. Petitioner prays for direction for release of back wages during the period when petitioner could not discharge duty due to termination order. Stop. Next paragraph. Learned advocate representing the petitioner is directed to produce copy of the writ petition being WPA 14868 of 2016 on the next date. Stop. Hearing of the writ petition stands adjourned. List the matter under the same heading for further consideration in the monthly combined list of December 2023.
A rule is in my favor. If my lord allows me, then I can fetch.
That's why coordinate bench directed continuity in service to be given. And that has been given by fixing your pay, taking note of your past service.
That is
Pay
one part.
fixation,
But-
continuity, everything.
And there is a 90% chance you will find that reinstatement with full back wages.
No, that-
Find out,
that is
go
the
through your
provision of
prayer.
law.
Yes.
That is the provision of law.
Yes.
My lord has seen the the order by which the
Next
incumbent
matter,
was
next matter.
reinstated.
Item number 64.
Better applicable extra matter. Matter the selection proceedings for the post of Anganwadi supervisor. Matter
Respondents.
is.
Respondents.
Last of sin matter appeared matter.
Well, not today. Let me see of tomorrow if anybody appears. Not today.
Item number 65.
65 on behalf of the petitioner,
Lord, I am for the Union of India.
husband of the petitioner,
All parties are present.
husband of the petitioner was soldier of Indian Army, was died.
Just a minute. Yes, affidavit of service.
November 2018, he was died during.
Who died?
Husband of the petitioner during the service tenure matter.
In harness, husband died. Died on
16th November 2018.
Yes.
Thereafter made application along with no objection from taken from the other legal heir. This is the page, annex.
Who is it's a you are claiming compassionate appointment. Now who is the petitioner? Wife.
Yes.
Wife petitioner. When the application was made?
My lord, application was made, but the application has been lost, so I never annexed with this petition. But after filing application, they starting the process, my lord. They start.
When application was made, I am asking you
Annex.
simple question.
That has not been annexed, my lord.
Why? Your right emanates from submitting application seeking appointment on compassionate ground. When you have applied for appointment on compassionate, it is not automatic process.
16th October 2020. That has been depicted from
Where is such application? 16th
I have no
October.
annex, my lord.
Then
But the date of the application has been mentioned.
what is your instruction? Any application was made for
My
seeking
lord,
the-
I cannot deny that because, my lord, yes, admittedly, there was an application. When the application was placed before the authority, my lord, 100, according to the 100-point roster, my lord, we have allotted. We have allotted the job to the on the compassionate appointment, but his the serial number was 34. For such reason, we could not. And we have informed her that yes, for this year, we could not. Next year, again, we will consider your case. Thereafter, she is saying that again she has sent, but that was not delivered to us for such reason.
Once petitioner was considered for appointment on compassionate ground and was enlisted, then it is the duty of the authority to process her application.
My lord, admittedly, my lord, we have
So
done so.
year after year, petitioner will continue to make application.
My lord, that is the scheme of the Indian Army, my lord, for such reason, my lord. That is key. If your lordship wants, my lord, I can show before your lordship. Because I
Show
can,
me.
yes, my lord.
Show me.
Well, because it is required. Because admittedly, my lord's query is correct. Once he has applied, how
and
can
she
he
was
day by
she was
day
found
there are
eligible to
yes.
get appointment, but because of her serial number or position in the list, she was not favored with an appointment on compassionate ground. Does it entail
Yes.
preferring
Again, she has to apply.
application seeking appointment on compassionate ground?
I shall.
Where is the provision?
I shall.
Not this week.
পারবে এই সপ্তাহের মধ্যে আনতে পারবে জজ সাহেব নট দিস উইক দিচ্ছে না তুমি 10 দিন টাইম নাও
Record an order. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner made an application for appointment on compassionate ground due to death of her husband in harness on 16 November 2018. Stop. Next paragraph, Mr. Bhattacharya, Mr. Banerjee, learned advocate representing Mr. Othurup Banerjee, learned advocate representing respondent authorities, on instruction submits that an application was made seeking compassionate appointment by the petitioner. When this application was made?
My lord, in the year 2020. I'm giving.
In 2020.
Yes, my lord, that was, my lord, in the year 2020.
In 2020, and same was processed.
Processed, my lord, in the year 2021.
And same was processed, and petitioner's name was and petitioner's name featured in the list of 2021.
Yes, my lord.
In the list of eligible candidates of 2021, but petitioner could not be favored with an appointment.
Each and every year, April 2021, next, my lord, April 2022,
Petitioner
by
could
this
not
way.
be favored with an appointment on compassionate ground in 2021, considering petitioner's position in the list. Stop. It is submitted on behalf of the respondent authorities that subsequently petitioner did not make application seeking appointment on compassionate ground, as a result whereof petitioner's claim for compassionate appointment could not be considered. Next paragraph, question arises for consideration. Once petitioner made application seeking appointment on compassionate ground, whether subsequently petitioner is required to submit application again. Stop. It needs to be recorded herein that based on submission made on behalf of the respondent authorities, that based on first application of the petitioner seeking appointment on compassionate ground, petitioner was enlisted in 2021. Next paragraph. Learned advocate representing the petitioner is directed to produce scheme of employment on compassionate ground, relevant scheme of employment on compassionate ground on the next date, in order to demonstrate or in order to show that petitioner is required to make subsequent applications for appointment on compassionate ground. Stop. Next paragraph. hearing of this matter stands urgent. List the matter under the heading motion on. Yes. When?
13th, 14th, any day.
After 18, my lord.
After
After 18.
personal, then will not kindly take it. After 2023, will not any date. Then, well, only because subject to any date. আমি ওই জন্য 13, 14 বলছিলাম।
Under the same heading in the monthly combined list of December 2020.
My lord, I'm grateful. ওটা ওদেরকে মেল করে দাও immediately, they will give it to you. আছে ওখানে একটা ক্লজ আছে, সেই ক্লজ।
Item number 66.
My lord, I appear for the
Respondent
petition.
number 6.
Petitioner.
NTPC is the main party, my lord.
NTPC.
NTPC. I am the Union of India, my lord.
Again
Respondent of-
NTPC.
Yes.
My lord,
You are representing.
my lord, before your
You are
lordship,
representing Union of India.
Only Union of India.
before lordship takes it up, my lord, I have gone through the affidavit of service. My lord, Union of India has been served. I find that NTPC has not been served because I'll tell your lordship why. I found from the here that, my lord, initially Ministry of Power Government of India was addressed because NTPC is under that ministry. Now they have cancelled it and only at Union of India's
To
ministry.
serve notice upon all and come back.
Only NTPC. My lord.
NTPC, Union of India is represented.
Yes, I am representing.
NTPC is one, respondent number one.
1
No,
to 5.
1 and 1.
1 to 5.
1 to 5.
Your main grievance appears to
Yes,
be against
Yes,
NTPC.
absolutely.
General Manager motion from. Issue. Learned advocate representing the petitioner pressed for accommodation to complete service of notice upon respondent numbers 1 to 5. Stop. Union of India is represented by learned advocate. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon non-appearing respondents by fortnight from date and file affidavit of service on the next date. List the matter under the same heading for further consideration in the monthly combined list of December 2020. Next.
Item number 67.
I appear for the petition, lordship. And here will be last order.
Other side.
Last.
Lord, kindly makes it not today because Lord, my learned junior has the original report in the form of an affidavit. He has left it, Lord.
Well, not today.
Yes, Lord.
Not
Kindly
today.
excuse me. Kindly.
No order today, not today.
Grateful, Lord. Extremely grateful.
Let it retain its position, not today.
Tomorrow.
Tomorrow application date, let me see. If there is a direction, indication in the list, it taken up seriously.
Item number 68.
State, my lord, I am appealing for the petitioner.
Madam, for the state.
The earlier occasion direction has been given to serve
State
copy
the government of India.
to the district judge of the, my lord,
District judge আমাদের কত?
It is 68.
69
that I served the notice and affidavit service. My lord, because the district judge is the answering
Just a
respondent.
minute, an order was passed. Who is appearing for respondent number 4?
Perhaps Mr. Devjit Mukherjee.
Mr. Gaurav Das.
Gaurav Das.
Where is he?
Correct.
Who is respondent number 4? Register General Appeal Side. Serve a notice, come back, not this week. Affidavit service, today you are filing.
My lord, earlier affidavit service filed as per direction.
Where you will take it back on the next date when an order is to be passed, then you will file.
My lord, remaining its own monthly. Next.
Monthly list, it will retain its position. You serve notice upon the learned advocate representing High Court, Calcutta.
Item number 69.
69 for the respondent number 2 and 6.
But in this matter, my lord, I am appearing with the petition led by Mr. D.N. Rai. Now, my lord, he was supposed to appear online, but maybe the connection or something must have been snapped or something like that. Lordship, can you take it up on Monday, my lord?
Tomorrow?
Tomorrow, my lord, perhaps he was having some difficulty.
Not this week.
As your lordship, please.
Mr. Chattopadhyay, come back.
As your lordship pleases. Grateful mind, much obliged.
Item number 70.
At the time of call, no one appears for the petitioner and no accommodation is paid for. Next paragraph, list the matter under the heading motion on 18 November 2024 for further consideration. Next paragraph, it is made clear for further consideration. Next paragraph, it is made clear if on the urgent date petitioner goes unrepresented, consequential order shall be passed. Next.
I am for the respondent.
Item number 71.
My lord, I beg to appear on behalf of the petitioner, my lord. My lord, I am challenging the maintainability of this writ petition, my lord, on the ground of alternative remedy.
Why? What alternative remedy?
My lord, this is a matter which relates to the promotion of employee of a Steel Authority of India. My lord, by gazette notification, the dispute ought to go to CAT. CAT. But my lord, they are. This is only for the promotion, my lord, and it is very short matter, my lord. Promotion has been granted, my lord. But
question is not that. Question is,
my lord,
why you have not approached Central Administrative Tribunal?
This is
See the notification.
I have not seen.
Which serial number? Steel Authority of India, Steel Company registered under the Company Act.
201.
Another minister. Present, this writ petition is not maintainable. Not on merit, because it's a maintainability point he is taking.
Alternatively, believe not bar, my lord. This
here it is barred. Here it is barred.
Can I see?
Court cannot exercise discretion.
Can I come tomorrow, my lord?
Very well, come back tomorrow.
I have to take instruction.
I'm keeping this notification. Not today. Very well, take it back. Place it on the next day.
As the lordship pleases.
Absolute bar, statutory bar is there.
My lord, let me satisfy your lordship if I can.
It is not a case of alternative remedy to prefer appeal before the appellate authority.
Promotion has been granted, my
You
lord.
need to approach the tribunal. If you fail or if you are agreed by the other tribunal,
My
then
lord,
you can come up
but
with the
my lord, the
petition
matter has
before
come
the
to
division
appeal,
may.
my lord. The promotion has been granted. They have been
If you
accepted.
go on arguing, then I will pass an order today. There is no issue.
Let me come tomorrow. Next day, my lord.
There is a specific forum. Have you gone through the Tribunal Act?
My lord.
My lord. Yes. Next, call the next matter.
Item number 72.
My landed friend is appearing while at his present, while at your lordship directed to sub-notice. As the
Hey, let it be called on. Let it be called on.
Seventy-two. 72, my lord, I am for the respondent.
Yes, you are for the
Respondent.
respondent. Issue. At the time of call, no one appears for the petitioner and no accommodation is paid for. So, you are representing state.
Union of India, my
Union
lord.
of India. Union of India is represented by London Advocate. Next paragraph. List the matter under the heading motion on 19th November 2025 for further consideration. Next paragraph. However, it is made clear if on the urgent date petitioner goes unrepresented, consequential order shall be